Yes, ma'am. Please come back on Monday. Monday we are taking up yes. Correction, yes, yes, and please. Please.
Listing for listing. No.
Application.
Application.
Yes, yours. Application.
Lordship, may I pray for your Lordship's kind leave, my Lord? I'm mentioning this matter under extreme compulsion, my Lord. This is a matter of 2017, my Lord. Notice of appeal, my Lord, has already been served. Everything is complete. But the difficulty is from 2019, there had been series of orders from the division bench, my Lord, for transfer of LCR. Yesterday also, my Lord, I myself had visited personally in the department. The department had asked me to approach your Lordships that unless there is because it's from the Howrah.
LCR has not yet come.
LCR has
From the Howrah Court.
From the Howrah Court from 2019, my Lord.
Please hand over the slip. We'll pass appropriate orders. It will appear as to be mentioned. Please give the caption to be mentioned. Just give a caption to be mentioned. Yes.
Lordship, there is a urgency for this application.
Hand over the order also because
It's not. At that point of when you take up the matter, you hand over.
Lordship, there's an urgency because I'm
the one which you mentioned. It will appear in the list. Whenever the file comes, it will be listed.
I have the lower court date is on 18th.
We can't help that. You're mentioning today. As soon as the file comes, it will be listed. Yes.
Lordship, may I permit to mention one matter, Lordship? This is the contempt application. Lordship.
Yes. And contempt of which court?
Lordship,
the order was passed by
22nd February.
Passed by which judges?
Lordship,
me and
Honorable Judge Shubhaji Bhattacharya. Code number 9.
Shubhaji Bhattacharya is I. Who else?
Code number 9, Lordship.
Singly, sitting singly.
Yes.
Mention when I sit singly tomorrow.
Lordship, this is a matter which was filed with FM80 number, which was defective, and under Honorable Justice Harish Tandon's order, it was changed, and that's why Lordship
what is this?
included. This is F80.
F80 for hearing, final hearing.
Yes, Your Lordship.
Not right now. Mention on Monday. Yes, call on this. Accordingly, F80 393 of 2014 is allowed, thereby setting aside the impugned judgment and decree dated May 6, 2014, passed by the Additional District Judge, First Court at Burdwan, in OS Will number 01 of 2013, whereby the application for probate of the will of late Renuka Datta was dismissed. Consequentially, the probate of the last will and testament of late Renuka Datta dated January 16, 2003 is hereby granted. The appellant is granted leave to approach the probate court for taking necessary ministerial steps for the actual grant of such probate in favor of the appellant at the earliest. If so approached, the probate court shall take immediate steps to ensure the same. There will be no arrest to costs.
It's my appeal, but unfortunately, Lordship has appeared for
I appeared for one of the parties?
The appellate, my Lord.
Oh. It is.
The oppositions can be kept filed.
No, nothing. Keep it with you. You are for the appellant. Learned counsel for the appellant points out that one of us, within bracket Bhattacharya J, had appeared for one of the parties while at the bar. Full stop. Hence, comma, for the sake of propriety, comma, let the matter stand released from our list with liberty to the parties to seek an assignment before a different bench.
Number 3.
Yes.
This matter postal cost or whatever writer rupees I will pay. I will pay the postal cost because in the meantime, when the order was passed in the year 2019,
right.
After that, subsequently thereafter, I said that we will not pursue that because of the fact that there was some internal bickerings among the family.
We'll grant you some time to put in the postal cost.
Yes, postal cost.
Well, learned counsel appearing for the appellant submits that the appellant shall put in the postal costs at the earliest, Full stop. It is also submitted that due to internal bickering between the appellants,
Appellants and in their family, my lord.
due to an internal bickering in the appellant's family, comma, the same could not be deposited earlier. Full stop. Accordingly, the appellant is directed to put in the requisites, namely postal costs, written up notice forms, and correct
And correct.
postal address of the substituted respondents for effecting service of notice of appeal by registered post with AD within a week from date. Full stop. In default, comma, the matter be put up under the heading Lozima for final orders.
I'm grateful to you.
Thank you very much.
Item number 4.
Yes.
Wait, please. Right for the appellate.
Item number 4, I've been appointed
It is the
by the respondent wife.
it is that matter, my lord, where the husband, my lord, has been sentenced in the order of the divorce as well. So, my lord, to suffer, my lord, imprisonment for 3 months, 3 years. So, my lord, what happens, my lord, the divorce suit, my lord, here.
You are enjoying a stay of operation of that.
Yes, it does. My lord, there is a direction for filing the paper book, my lord, which is ready, my lord, which is not filed.
Otherwise, it's ready for hearing.
Yes.
Paper books you are filing.
Yes, my lord.
You want to file today,
Yes, my lord.
and you have given copies to them.
Yes, my lord. By post, I have served upon his
Client.
As of now, I have not received anything.
I do have another copy.
You can give another copy to him.
Yes, madam.
We will fix the appeal for hearing on Monday.
Monday, I do have a difficulty. Monday, my lord, I have.
Why is it appearing as to be mentioned then?
But because it is coming in the laws in my heading, my lord, I mentioned.
For filing of paper books.
Yes, ma'am.
Oh, all right, very well. The paper books filed in court today be kept on record. Full stop. Next para. Accordingly, there is no further defect, and the appeal is otherwise ready for hearing. Full stop. The learned counsel, the learned advocate for the appellant is requested to hand over a copy of the paper book on his counterpart, having instruction to appear for the respondent wife by tomorrow. Full stop. Next para.
I've already given.
Oh, full stop. তাহলে যে লাস্ট সেন্টেন্সটা কেটে দিয়ে the learned advocate for the appellant hands over a copy of the paper book on his counterpart appearing for the respondent. Full stop. Let the appeal be listed next week.
My lord, there was another, my lord, endorsement in, my lord, in the reporters
That
the wakalatnama that my learned friend has filed, my lord, has filed without getting no objection from the earlier learned lawyer.
no, you have to file no.
No, my lord. What happened actually, my lord, last order speaks that my lord justice
You have to have a no objection. What about that?
no objection. I have been appointed, my lord. Last order, my lord justice Prasad directed the legal aid to communicate the respondent without the permission of the respondent, my lord. That is no Vokalatnama as of now probably filed. So I have been instructed, my lord, I will file in course of the day.
Previously, there was
No.
no Vakalata filed at all, but that's an endorsement of the office.
I was there.
Erstwhile advocate was Mr. Gaurav Purukas.
Your respondent.
Yes. Yes.
Then, my lord, I have
You have to take আচ্ছা তাহলে এটা
But I think, my
একটু
lord,
চেঞ্জ করে দাও লাস্ট লিস্ট সেন্টেন্সটা বললাম দ্য অ্যাপিল উইল বি লিস্টেড ফর হিয়ারিং ওটা কেটে দাও আর যেখানটা বলেছি লার্নেড অ্যাডভোকেট ফর দ্য রেসপন্ডেন্ট সেখানে লিখে দাও লার্নেড অ্যাডভোকেট হ্যাভিং ইনস্ট্রাকশন টু অ্যাপিয়ার ফর দ্য রেসপন্ডেন্ট সো নেক্সট সেন্টেন্স প্যারাগ্রাফ the learned advocate having instruction to appear for the respondent comma having been engaged by the legal aid comma is directed to take steps immediately for obtaining no objection certificate from the previous erstwhile learned advocate through the legal aid services. Do that. Otherwise, you know what to do. The client has to write a letter, and you can take leave from the court too.
one thing, my lord. I am not appointed by legal aid, my lord. Last order was that Justice Prasad directed the legal aid service to communicate the respondent. Now, respondent communicate after getting this notice. Respondent communicate to me that
দু জায়গায় ইউজ করেছি থ্রু লিগাল এড সার্ভিসেস দুটোই কেটে দাও ফাইল নো অবজেকশন
I have no instruction to that effect, my lord. I will file.
the matter is, my lord, returnable, my lord.
we have not made it returnable unless he files a wakalat no it's defective.
My lord, I think, my lord, it is no more adversarial because they filed for divorce. They
They have to file a wakalat nama.
My lord, in course of the day, I will obtain the objection, my lord.
You cannot. The client is with you here.
My lord, he is coming. She is coming, my lord.
Do that and get it mentioned. We'll include it in the appeal in the list. But do that first.
My lord.
Do that first. Inform your learned friend, Mr. Rai. Both of you can mention the matter for inclusion in the list next week.
My
Because the regular bench will be resuming next week. Thank you.
Five, my lord, I am for the appeal.
Yes.
I would beg my lord's pardon because I have not been able to check up the record and inquire as to what is the
you are the appellant. You are for the appellant. Special messenger cost of rupees 150 out of time. We are accepting that. The office report dated January 6, 2025 indicates that the special messenger costs as directed earlier has been deposited late by the appellant. First up, we accept the said deposit on condonation of delay in making such deposit. First up, accordingly, the office shall take immediate steps for ensuring that the trial court records be brought by special messenger. First up, upon arrival of the records and the same being found to be complete, a notice of arrival of the records shall be issued on the learned advocate for the appellant. First up, the learned advocate for the appellant shall then prepare and file the requisite number of paper books within 8 weeks thereafter. First up, liberty to the parties to mention the matter for enlistment as and when the appeal is otherwise ready for hearing.
I'm grateful.
Six Mela special messenger cost has been deposited.
Out of time?
On 9th of December 2024.
No, you have to put in requisites.
Requisites also. Another 7 days. I'll do it.
The office report dated January 7, 2025 indicates that requisites including written up notice forms, declaration, etc. have not been put in by the appellant. Push-up learned counsel for the appellant submits that the same will be deposited within a week from date. Push-up. Accordingly, the appellants are directed to put in the requisites within a week from date. Push-up in default, the matter be placed in the list under the heading Lozima for final order.
Grateful.
I'm opposing this application.
Seven.
I'm opposing this application.
I'm
I'm for
for-
the appellant.
Petitioner, my lord, I'm appealing for intervener, my lord, National Stock Exchange, my lord, my affidavit service. Lord, your Lordship
National
will
Stock
look at-
Exchange is the yes, it is the appellant. Right.
Lord, your Lordship will turn to annexure A, my lord. Lord, the appeal was disposed of, my learned friend's appeal was disposed of, my lord, by passing the order, page number 2, your Lordship. We dispose of the appeal by
No,
remitting the matter.
page, which page of the
Lord,
application?
this is annexure A, my lord, page 12, and your Lordship will kindly come to page 13, my lord.
It's not paginated in my copy.
My lord, it's bottom, my
Oh,
lord.
sorry.
I'm sorry.
Yes, 30, right.
Lordship will come to page 13, my lord.
Yes.
We dispose of the appeal by remitting the matter to the learned arbitrator of National Stock Exchange for reconsideration in terms of the impugned judgment and order, my lord. My lord, thereafter, my lord, your Lordship will see the learned arbitrator is one Mr. Debashish Mukhopadhyay, my lord, in paragraph 2 on the same page, my lord.
Yes.
Learned arbitrator is one Mr. Debashish Mukhopadhyay. My lord, thereafter we intimated, my lord, we were not party, my lord, we were not aware of this order, my lord, being passed, my lord. My lord, whereafter we intimated to Mr. Debashish Mukhopadhyay, my lord, which your Lordship will see page 33, my lord, annexure F.
Yes.
My lord, this letter came back, my lord, with the remark, my lord, we sent the order copy also, and your Lordship will see annex G, my lord, page 45. My lord, he is dead, my lord.
There
It
was
has come back-
Mukhopadhyay.
Mukhopadhyay, he died, my lord. It came back with the remark, deceased, my lord. It's only that, my lord, I'm just seeking, my lord, your Lordship
Yes.
kindly direct, my lord, we have panel of arbitrators. My lord, we will
What was
submit
the purview of this appeal? I mean,
investors dispute, my lord, basically.
investor dispute, and let us see the entire order of Justice
Yes,
Mukherjee's
your
bench.
Lordship will kindly see, my lord.
Uh,
Page
let-
12, my lord.
Please place from page 2 the first sentence. I mean, internal page 2, page 13. I'm sorry.
By the impugned judgment and order of the learned Chief Judge, Citizenship Court in the application taken out by the respondent to set aside the award in favor of the appellant, the learned judge set aside the award, which was in favor of the appellant, and sent it back to the learned arbitrator for reconsideration. The learned arbitrator is one Mr. Debashish Mukhopadhyay, who was appointed by the National Stock Exchange as submitted by Dr. Sahare. In the facts and circumstance case, first of all, we allow the application for condonation of delay in filing the restoration application. Secondly, we allow the application to condone the delay in filing the appeal. We restore the appeal by allowing the application to restore the appeal, which is can number 1, 2, and can number 3, or allowed. Then we dispose of the appeal by remitting the matter to the learned arbitrator of National Stock Exchange of India for reconsideration in terms of the impugned judgment and order. We can justify this order in this way. The respondent has not preferred any appeal from the impugned order and thus taken to have accepted the order. The order that we now pass does not set aside or vary the impugned judgment and order. Thirdly, and most importantly, the respondent have been served with the copies of the above application and have not come forward to oppose the prayers made therein, Lord.
So this was sent for reconciliation to the arbitrator.
Yes.
You say the arbitrator is deceased.
Yes.
So you seek a direction on you can give a direction.
Any person can be appointed, but we furnish a list of arbitrators, panel.
Right. Yes, what do you say? Dr. Sahara,
fair submission with deepest respect. I humbly
person is
submit.
dead. What can be done?
There is a lackadaisical approach on the part of the National Stock Exchange. Why I am telling you, Lordship?
Whatever, now it has to be complied with. This order has to be
But this order, whatever that your Lordship will kindly find that there are two set of orders passed by the trial court.
Stock Exchange was a party to this litigation.
The Stock Exchange was not a party, but it was intimated to the Stock Exchange, and the Stock Exchange sat idle over this, sat tight over this matter.
When was it intimated?
Well, it was in 2011. This order has been passed by the trial court, specifying that this arbitrator will reconsider this issue. And what happened thereafter, they take out an application, that is the brokers took out that application specifying for changing of the arbitrator under section 151.
Dr. Shahra, the difficulty is now the National Stock Exchange is not a party to the dispute. Now that dispute has been referred back to the arbitrator for reconsideration.
But it was referred in 2011.
This order was passed
24,
in August 24.
No.
22nd August 2024.
This is pertaining to.
This is the last position in the matter, Dr. Shahra. Whatever may have happened before that, this is the last position. This court has directed on August 22nd, 2024 for the matter to be reconsidered by the arbitrator. Now, this order you were present and you had assisted. You had not pointed out that the arbitrator was.
We have not been intimated either. No.
Who will intimate you?
But the National Stock Exchange never intimated. We have given them.
Why should they intimate you? Because the matter is in arbitration and an award has been passed. You have challenged that order before the City Civil Court.
Yes.
Now, that order is before this court. Why should the National Stock? Their job ends with appointment of an arbitrator.
I tell you, Lordship.
So, Dr. Shahra, we will appoint a fresh arbitrator and so that this order is carried out.
Appoint a fresh arbitrator and stick to the point. Lordship, kindly see the trial court.
This order will be complied with. Only the arbitrator will be changed.
No new document can be furnished.
Nothing else. We cannot deviate. They are not asking even for that. They are rather helping you by seeking to appoint a new arbitrator.
I'll give a list of panel.
They'll give a list of panel to you. And to the other side also it has to be given.
I shall.
But they haven't furnished the when he died. That has not been furnished.
I have got to know only from the notice, my lord. I don't know.
There are certain.
Are you disputing that he has died?
But we are not aware about it.
You have got a copy of this application. You should have taken instruction.
Because no death certificate has been furnished.
Dr. Shahra, we cannot be very technical on this because they are only trying to help you. We can very well reject.
They should have.
Let us say this, Dr. Shahra. Let us reject this application. This order will not be complied with. Will you be happy with that?
I
mean, you are taking an unnecessarily adamant and unnecessarily, recalcitrant attitude.
Lordship, kindly don't.
They are trying to help you by appointing an arbitrator since the arbitrator is dead. This court, at your behest, has directed a reconsideration by the arbitrator.
Yes.
Now you are opposing an application whereby they want to appoint an arbitrator. Let us reject this application on your recording your opposition, and there will be no arbitrator. Let this order not be complied with. You will be happy with that.
One thing I just.
They are only wanting an arbitrator appointment.
Lordship, I want
Lordship, why oppose everything, Dr.
Lordship, I never oppose. Lordship,
just because you are
Lordship, Lordship,
you never oppose. You always oppose.
Whatever the logistic approach, I generally approve. What happened, Lordship, kindly approach.
Logistic and logical.
But the award, what they have done and mess of it. The award has been passed of certain.
They are wanting to get out of the mess and you are resisting. It's like what, shall we tell you? Suppose someone has died, a defendant has died in a suit. The plaintiff does not file an application for abatement, setting aside abatement. And the defendant files an application and the plaintiff opposes it. It's like that. They are trying to help you only to comply with this order.
I am on that.
We are finished with this hearing, Dr. Shahara. Either you object and we reject the application, or we direct them to give a panel of arbitrators to you as well as the other side in the dispute, and an agreed arbitrator will be appointed.
Appointed, and he will do the as per the order passed by this trial court.
Why should you add something to this order? He will only comply with this order.
Yes, because they will try to in de novo.
They will not try to do anything. They don't have any interest in the matter.
But they have already handed over the money to these
Maybe.
But that cannot be done because they should have withhold that money.
Dr. Shahara, whatever will be the outcome of the dispute, they will avoid by that. They are the stock exchange. Learned counsel appearing for the applicant stock exchange submits that by an order dated August 22, 2024,
some limited time may be given.
2024, a coordinate bench of this court had disposed of an appeal preferred by Oshim Talukdar, the appellant, bearing FMA number 448 of 2017, pushed up in the said order, the division bench had recorded that the learned arbitrator was one Devashish Mukhopadhyay, who was appointed by the National Stock Exchange of India within bracket the present applicant bracket closed, as submitted by learned counsel for the appellant himself. Pushed up. Ultimately, the appeal was disposed of by the coordinate bench by remitting the matter to the said learned arbitrator of the National Stock Exchange for reconsideration in terms of the impugned judgment and order. Pushed up. Next para, learned counsel appearing for the National Stock Exchange points out that subsequently, when the order was sought to be communicated to the erstwhile learned arbitrator Sri Devashish Mukhopadhyay, the track report indicated that the said learned arbitrator had expired in the meantime. Full stop. Next para. Accordingly, the innocuous prayer made in the present application is seeking appointment of a new arbitrator upon furnishing of a panel of the existing arbitrators of the National Stock Exchange to the parties to the dispute. Full stop. Next para. Learned counsel appearing for the appellant stroke respondent in the application opposes the application and submits that the National Stock Exchange has shown recalcitrant attitude by not informing about the demise of the learned arbitrator to the appellant. Push up next para. However, we do not find any adversarial component in the present application, since what the National Stock Exchange is seeking is only to facilitate a proper implementation of the order dated August 22, 2024, which inures to the benefit of the parties to the dispute, including the present appellant. Full stop. Next para. In view of the demise of the erstwhile learned arbitrator, the order dated August 22, 2024 can only be implemented by appointment of a fresh arbitrator. Full stop. Accordingly, Can 4 of 2024 is disposed of by directing the applicant stroke National Stock Exchange of India to furnish a panel of the existing arbitrators of the said stock exchange to both the parties to the dispute within a fortnight from date. Full stop. Next para. Upon such names being furnished, the parties shall agree to the to a common name of an arbitrator for such appointment. Full stop. Such communication regarding acceptance shall be intimated by the parties to the National Stock Exchange within 3 weeks thereafter. Full stop. Next para. In the event no such communication is made within 3 weeks, the National Stock Exchange shall choose one of the arbitrators from the panel. In the event no such communication is made, and or in case of disagreement between the parties as to such appointment, the National Stock Exchange, after awaiting the said period of 3 weeks, shall appoint one of the arbitrators from such panel and intimate about such appointment to both the parties to the dispute within a fortnight thereafter. Full stop. It is made clear that upon the fresh appointment being made, the newly appointed arbitrator shall step into the shoes of the erstwhile learned arbitrator and shall comply with the order dated August 22, 2024, passed in FMA 448 of 2017, without any deviation from the same.
I'm deeply obliged.
No orders to cause are decided.
I'm deeply obliged.
Thanks.
Deeply.
Affidavit of service filed to be kept on record. Every matter has to be opposed, Dr. Sir. We are helping you out.
But I always try to help the court. Lordship knows me.
Yes, yes, I know you.
And for the petitioner,
Yes.
I'm at fault.
Why? What did you do this time?
Lordship,
Section 5.
Lordship, supplementary I could not prepare, and the stamp also I could not put in.
24th December,
I know.
before the vacation, sir.
Somehow it's missed my
I
mind.
give you 1 week's time for that.
Yes, Lordship. I thought that on second I will give and then I will do it.
Very
Somehow
well.
it's
Very well.
slipped
Learned
out.
counsel for the appellant seeks further time to comply with the order dated December 24, 2024. Since the supplementary affidavit could not be prepared and the deficit court fees also could not be put in the meantime. Full stop. Next para. Accordingly, on the prayer of the appellant, comma, a further fortnight's time is given to the appellant to comply with the directions incorporated in the order dated December 24, 2024. Full stop. The matter, the application shall be listed. No, sorry. Eta kete dao last sentence. The department, comma, upon such deficit court fees being put in, comma, shall furnish a fresh report to that effect, which shall be tagged along with the file. Full stop. Such report shall be prepared within a week from the deposit of the deficit court fees. Full stop. Liberty to the parties to mention the matter for inclusion in the list thereafter. Just keep track, Mr. Banerjee. Whenever they give that report, mention it. We'll include and
9, Lordship, I am for the appeal.
yes, Mr. Rai. What is the matter?
Lordship, this appeal arises of a preliminary degree passed in a partition suit. Lordship.
This is appearing for the first time without any caveat.
No, there was a caveat.
Was
We
a
have
caveat?
already intimated him.
Just file the receipt.
Lordship, I'll place the matter first, Lordship.
There was some defect.
Yes, there was a defect, Lordship. The stamp reporter has stated that 30,000 stamp duty has to be paid.
Yes.
But this is a partition suit, Lordship. Sufficient stamp duty has been paid. And we are coming against a preliminary degree. My fault, Lordship, I could not list the matter before any bench earlier, Lordship. If Lordship will kindly consider the stamp reposer's report.
Yes, the valuation is that. No, you have sought for a cancellation of a judgment and degree also.
The
suit for declaration,
for the
partition,
degree, yes.
cancellation of judgment and degree.
Yes.
They have sought for cancellation of judgment and degree is a separate relief on which the partition depends. We find this from the impugned decree.
Yes.
Page 2 of the impugned decree, the caption of the suit is given declaration, partition, cancellation of judgment and degree.
Yes.
If it's also cancellation of judgment and degree, then even if it's a partition suit, partition is dependent on that cancellation of a previous judgment and degree. So you have to put in the
declaration, partition, cancellation of judgment and degree,
Yes, yes,
permanent
yes.
injunction.
Your partition is not standalone. I mean, it is dependent on that you are the defendant in the suit.
Yes.
Then also, but cancellation of judgment and degree is there.
Till then the stamp has to be paid according to 100 rupees for the partition suit.
Let us see
It
the
has not
decree.
been. It is not been stated separately, Lordship.
No, but the valuation. Let us just check up the decree once. ও তো টিউশন রাইট যদি অ্যাজ আ পয়েন্ট ফাইনাল ডিগ্রি Rai, please take your seat. We'll just take 5 minutes. Right. Mr. Rai, please come to page 3 of the decree. You have to put in the deficit code fees because that
Page 3.
yes, it's page 3 of the decree. See the second paragraph. It is ordered that the suit be and the same is decreed on contest. That was the previous decree. No, that the previous decree is.
No.
Yes, sorry. About the third paragraph from the bottom. Both the preliminary decree dated such and such and the final decree passed and obtained in the previous suit are hereby set aside and they no longer remain in force. That has otherwise the shares could not be declared. So you have to put in the entire code.
Give me 1 week's time.
Yes, definitely. We'll give you time. And something else remains also, any other defect?
No.
This is the defect.
This is the only.
We'll record your submission on this and we'll decide on this point and ask you to.
Yes.
Learned counsel appearing for the appellant points out that although the report of the additional stamp reporter indicates that deficit court fees are to be put in by the appellant, the present appeal has been preferred against the preliminary decree of partition by the defendants in the partition suit, and as such, the usual court fee in respect of partition is required to be paid. Push up next para. Upon a careful consideration of the impugned judgment and decree, we find that the plaintiff in the suit did not merely ask for partition, but the relief of partition was consequential upon cancellation of a previous judgment and decree, which was also a part of the relief claimed in the suit. Push up. Accordingly, the suit was valued at rupees 15,00,200. Push up next para. Thus, the relief of partition in the present case, is consequential upon the other relief of cancellation of judgment and decree. Push up. Moreover, there are other consequential reliefs as well. Push up. Accordingly, we stand by the report of the additional stamp reporter. Push up. The appellants, thus, are required to put in the deficit court fees. Push up. On the prayer of the learned advocate for the appellants, we grant a week apostrophe time to the appellants to put in the deficit court fees. Pushed up. Next para. Upon such deficit court fee being deposited, the office shall within a week thereafter, furnish a report to that effect and tag the same along with the main file. Pushed up. The file be sent down to the department for such purpose. Pushed up. Liberty is granted to the appellants to mention the matter for inclusion in the list as and when such report is furnished by the department. It has to go down, otherwise you cannot put in the code. Immediately after that, mention it will.
Refusal of administrative injunction, Lord.
No caveat for the first time.
For the first time, no caveat, Lord.
Refusal of administrative.
Lord, from city civil court.
Appeal was admitted, no?
No, from city civil court. Lord.
আচ্ছা এই শুনুন appeal admit হয়নি but formidable adversary than justice Sandman. It has to be admitted first. It has to appear under the heading. You mentioned as application must have been. আপনাদের. Yes. Why did you mention as application?
Should not have.
Let it appear under the proper heading. Although the matter was mentioned to be incorporated in the list under the heading application, since the appeal has not yet been admitted, let the same be listed on January 13, 2025 under the heading Order 41 Rule 11 of the Code of Civil Procedure.
Fine. Good.
Because somebody may be watching Order 41 list.
petition, my lord. Mr. Banerjee, Sudhashattu Banerjee is leading me. He could not come to court today. Ill health, my lord. He's requested, my lord, if the matter could be adjourned, kept sometime in next week, as per your lordship's convenience.
What is the application appearing?
My lord, the CCTV matter.
Installation of CCTV, my lord, in my own house.
Not only in your, you are not the sole owner of the house.
He's not the
In your own house and their own house also. Not their house. What? So what do you do? Adjournment?
Extend the interim
My
order.
lord, interim order is expiring tomorrow.
Kindly do not extend
No,
it
kindly
formal.
extend the interim.
No, Mr. Gaura, you cannot ask for adjournment and
lord, kindly.
ask for extension in the same
My lord,
day. Then you have to
No,
move
it's
on.
just on the health of Mr. Banerjee that I have asked.
শোন বাবা formal extension করিস না এইটুকু তো বোঝ
No, Mr. Gaura, no. Even if Mr. Sudhashattu Banerjee is keeping ill health, we won't extend the order in the same breath by granting you injunction.
Mr. Banerjee called me in the morning.
We don't dispute Mr. Banerjee's. We don't have any quarrel with Mr. Banerjee's health.
Absolutely.
And we
Well,
are
I told
fully
him that, well, I
sympathetic
will
to
not
Mr.
stand in the
Banerjee.
way of the prayer
But it's
for
a matter of
adjournment.
principle, Mr. Gorai. We cannot grant you adjournment and extend the interim order in the same.
But the lordship has granted.
Move the matter. We give you the option. Or we don't grant the interim. You will keep it whenever you say, but no extension of interim order in the same breath. No.
My lord, the interim order only for a day's accommodation. Tomorrow, your lordship will, had it been tomorrow, your division bench was sitting, I wouldn't have asked for the extension and kept it tomorrow.
Don't put the blame on the court, Mr.
I'm not.
This is the second mistake you are
And I am not. But tomorrow,
the court has its own roster.
Yes.
You know from the inception of when the court is sitting, we take up single matters on Fridays. It's not beyond your knowledge. You could have mentioned before. You could not have asked for interim order extension or adjournment. Don't ask for adjournment, move the matter. You know very well that the court sits singly tomorrow. No, why did you say that the court? I'm sorry, Mr.
I
Gaur.
apologize.
This is
I
very,
apologize.
Mr. Garai, don't shout your apologies. Your apologies need not be shouted. They should be imminent from your approach.
I did not.
No, you specifically stated if the division bench was sitting tomorrow, Mr. Garai, don't you know? Doesn't Mr. Banerjee know that the court does not sit in division bench on Fridays? That has been the practice of this court, and that is not for our own picnic. Because we take up singly, we take up matters which are part heard or contempt matters for which people have been directed to appear before court. People who are in dire states, not like you. You belong to a creamy layer of society. You are an advocate having some practice in this court. The litigants may not be. They are directed to appear in courts in the single determination. That's why you take single determination on Fridays. Why do you say that if the court sat in division bench? The court does not sit in division bench.
Apologize, I did not.
Either you ask for adjournment or you pray for extension. You cannot do both.
I did not mean that. Lordship will kindly not take me. Well, Lordship will kindly
On the prayer of the appellant, the matter is adjourned for the week. Next.
Well, Lordship will.
No, this is too much.
But I
Sorry.
apologize.
No, Mr. Garai. Your apology is a lip service.
No.
Call on the
I
next matter.
did not want
Call on
to
the next matter. You are sufficiently senior for this.
I did not.
You cannot blackmail the court.
I did not.
No, you cannot blackmail the court.
Kindly, Lordship will not.
Call on the next matter. Adjourn for the week. Kore deben. Next.
My lord, kindly do not take me away.
Call on the next
Kindly do
matter.
not take me away.
ওটা পরে করবেন ওখানে ডাকুন আমাকে ডাকছেন কেন ডাকুন মুখে বলুন yes move the matter
Section
you have
5 is there.
filed a section 5 application
Section 5 for 4 days delay, my lord, and my
4
lord,
days?
4 days. And my lord, there's an injunction application. My lord, I'll lock, stock, pedal, my lord, serve everything, my lord, on the opposite parties, my lord.
the appellants shall serve copies of the applications and the memorandum of appeal on the respondents, indicating that the applications shall be listed on January 20, 2025 for hearing. On the said date, the appellant shall file an affidavit of service to that.
January 25th, my lord.
January 20th, we said.
20th.
20th January.
20th.
Yeah, next. Honorable? Honorable? না না হবে না কি করব Yes.
I for the respondent, my lord.
Yes.
For the appellant, my lord.
I'm submitting the affidavit in reply.
Yes.
This is my affidavit.
I've
opposition.
already served. I've already served upon them.
But your lordship, my lord, in this matter, my lord, yeah, I'll place some time, my lord.
Why?
Because, my lord, one document is required, my lord. Kindly, my lord, one
You are
document
enjoying a stay
compromise-
order.
Yes,
my lord.
they are enjoying it.
When do you want us to keep it?
7 days time, my lord.
On the prayer of the respondents, the matter is adjourned till January 16,
My
2025.
lord, direct my lord, to produce my lord, the accounts. Your last question, your lordship directed my lord to
No,
maintain the accounts.
My lord, your lordship has directed us
Yes.
to maintain the accounts, and wherever required by the court, we should submit, my lord. There is no.
We will not
direction
pass any
to submit.
direction to that effect today.
The opposition file, my lord, kept in.
Affidavit in reply has also been filed. I have served.
আচ্ছা
copy.
আরেকটা লাইন অ্যাড করে দাও affidavits in opposition and reply filed today be kept on record. Next.
Yes.
And my lord, there is an interim order of stay.
Till
Interim order of stay
till
till the next date of hearing. Till the next
Yes,
date of hearing.
yes. Extend this.
interim order was granted till when? What is the order?
Order month. Under the interim order,
Give us that order, we'll decipher or not. The disposal of the application. Application has not been disposed of. Thank you.
Lordship, on behalf of respondent number 1, I am being led by Advocate Abhishek Prasad, Lordship.
Glad to know that.
So
Move the
far,
matter.
so far,
Glad to know that you are led by somebody. Move the matter yourself.
so far item number 14th is concerned.
Yes.
I am HON'BLE FAT 294. Lordship, I have
Complete your sentence. Complete your sentence,
Lordship,
quick.
I have sent all the parties, but only one track report is available.
You are for the appellant.
I am for that. Appellant, this is the application under section 5.
You are appealing for whom?
On behalf of respondent number 1, Lordship.
Who has been served?
One track report is available. That is also not clear whether delivered or not.
But he is appealing. The
Lordship.
others, it's not clear.
Other is
In
not
respect of Lordship, FAT 294 of
But
2024.
Goyanath, Lordship, so far the Goyanath Mondal is concerned, who is the plaintiff respondent hearing. Let's see, he is the principal
in
opposite. Lordship.
This is against the preliminary decree.
This is against the ex parte, Lordship, the final judgment and decree. Ex
Final.
parte.
Ex parte means is equally valid, but it's a
Lordship,
final
the-
degree.
My content, final.
Final
My
degree.
contention is, Lordship, no notice has been served upon this appellant. Lordship, the one suit-
No. The difficulty is in a partition suit. It is not that only the plaintiff is required to be served. All have to be served. This is a partition suit.
Now, the
Effect will be on
second
all.
matter, so second matter, the other defendants are the appellant. Here, the only out of 5 defendants, 1 defendant is the appellant, Maya Mondal, and in the other matter, other defendants are the appellant.
So they are not appearing today.
Lordship, we have received
You are for the plaintiff appellant, plaintiff respondent.
respondent number 1 in respect of FAT 294 of 2024, which is item number 14, Lordship.
Yes.
And in the other matters, we haven't received any copy, Lordship.
But the advocate for the appellant in the other matters,
Other matters appellant is our part, Lordship.
you are the advocate.
Advocate. Because, Lordship, this is against the 5.
You are appearing for the appellants in both the appeals.
Both the appeals.
So why haven't you served the copy of the other?
Lordship, so far this matter is concerned, Lordship, I have the instruction that we will engage.
This means both matters are appearing before us.
Both matter is appearing.
Why do you say this matter?
No,
This matter, that matter. 14 and 15 are appearing together. They are against the same decree.
Same decree.
This
Same
matter, that
judgment
matter.
decree,
I didn't do. What about the service in the other matter? 15.
Yes.
Yes means? What is the meaning of yes?
15.
All have been
This is
served.
also served, but plus the track report showing not delivered to the plaintiff opposite respondent number 1.
Affidavits of service filed today be kept on record. It is seen that the service has not been completed on all the respondents. So accordingly, let the matter stand over till January 20, 2025, when it will be when they will be listed under the same heading. Next.
Copy the
Item number 16.
Can the matter be fixed on 21st or 22nd?
Let it appear on 20th. If you have difficulty, mention. But come ready. Even if you have difficulty, we may insist that you do the matter.
As per my instruction, Lordship, my senior's mother is having an operation on 20th this month. That's why.
Again, matter 21st. 21st. It will appear on 21st. Yes, Mr. Banerjee, what about
Look,
this?
the affidavit of service I've prepared. The difficulty was, my lord, I've identified why, my lord, it's not going, my lord. In the decree, my lord, the pin code has been, my lord, mentioned wrongly, my lord. When I, my lord, prepared the memo, I saw it from the decree.
You can make the necessary corrections.
Only the pin code, my lord, from 68, it would be 9. Kolkata 70068 to 19. And, my lord, I can send it, my lord, to the actual address.
What is this you have served on whom?
Served on, my lord, on the last occasion, your lordship, my lord, directly.
At that pin code.
At that pin code.
You are challenging what?
Challenging, my lord, and grant of probate.
Oh.
Grant of probate, there is, my lord, 2 applications, one for section 5, one under, my
The
lord.
affidavit of service filed today be kept on record. Full learned counsel for the appellants points out that the service could not be effected, apparently because of erroneous mentioning of the pin code in the address of the respondent, even in the decree of the trial court. Next para. Accordingly, leave is granted to the learned advocate on record for the appellants to carry out the necessary correction of the pin code in the address of the respondent in the cause title of the memorandum as well as the applications of the present appeal during the course of the day.
Yes, now only.
Full stop. Next para. Fresh service shall be affected at the correct pin code and a further affidavit of service shall be filed by the appellants on the next returnable date. The matter shall next be listed on January 27, 2025 under the same.
Great.
On behalf of the appellant, my lord, there is 2 applications. There are 2 applications. One is section 5 application and one is application for.
No service affected as yet.
Service was not yet done, my lord. The order be passed and we will serve the copy.
Fair. The
One indulgence, my lord, the execution proceeding is subject to held on 10th, lordship. That's some sort of.
10th.
Yes, lordship. Yes,
10th
sir.
of
Held tomorrow.
Nothing can be done. Your section 5 is pending. If your section 5 was not pending, we could have granted stay expertise. But unless the appeal, the delay is condoned, we cannot do that.
Well, then the necessary order be passed, then I will serve the.
Write to your counterpart in the court. Will at least fund it.
I will apprise.
The appellant shall serve copies of only the plaintiff. What is the suit? Eviction suit. Very well.
This is a 2G.
2G. Oh, then you are gone in any.
I am the tenant. I know it very well.
The appellant shall serve copies of both the applications on the plaintiff respondent number 1, indicating that the applications shall be listed on January 20, 2025 under the same heading when an affidavit of service to that effect shall be filed by the appellant.
Grateful.
Or I am appearing on behalf of the
Yes,
appellants. There are section 5 application is there now.
This is appearing for the first time, Mr. Gupta?
Yes, ma'am.
So we'll direct you to, you are appearing for the respondent?
Yeah, hard to copy.
Oh, then we can hear out. Yes. What is the delay?
Delay is 214 days, Mala.
What is the explanation?
Recalling application was filed from the degree that was heard, my lord. That was this one. Learned trial court said that as the degree has been already drawn up, you prefer an appeal. That's why, my lord, delay has. That's why the delay was happening.
This is against what decree?
My lord, this is directly the ex parte decree, my lord.
Eviction.
Eviction. Upon and on application under order 12 rule 6, my lord, which was neither served nor filed with, in the court below, trial court.
What do you say to the section 5? We'll record your opposition. Very well. We'll come to the stay later. Let us. Can 1 of 2024 has been filed for condonation of the delay in preferring the appeal. Full stop. Heard learned counsel for the parties. Full stop. Next para. The ground indicated in the application for the delay is that previously an application for recall of the impugned decree was filed, which was subsequently dismissed with a rider that the appellant ought to have preferred an appeal. Full stop. Next para. Upon hearing learned counsel, we are satisfied as to the bona fides on the part of the appellants in preferring the appeal late and accordingly condone the delay. Full stop. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay in preferring FAT 395 of 2024 without any orders to cost. Full stop. The appeal shall now be deemed to stand registered and admitted. Full stop. Can 2 of 2024 is now taken up for hearing. Yes.
Wants to file affidavit.
Affidavit, no question. Let there be a limited stay then. Otherwise, it will become infectious.
Since order 12 rule 6, on the basis of the written statement admission, this order has been passed, your lawsuit cannot to fix the appeal yourself.
Appeal along with the application.
Earlier occasion, your lawsuit passed similar one.
Yes, yes, absolutely. So we only have to look to the plaintiff and the written statement.
Yes.
But you have to prepare informal paper books at least. Incorporating these only, the memo. So you'll prepare informal paper books within a fortnight. Just annex these documents, put it in a paper book and hand over a copy to them. Next para. We find that the present we find that the present appeal has been preferred against a judgment on admission, and as such, the code is only to look into the pleadings of the plaintiff and the written statement for deciding the appeal itself. Pushed up. Accordingly, on the prayer of the parties, we decide to fix the appeal along with the application. Push up. The appellants shall prepare informal paper books without comparing with the records within a fortnight from date and give an advance copy of the same to the learned advocate for the respondents. Full stop. Next para. In the paper book, all relevant documents shall be incorporated by the appellants. Full stop. Next para. The appeal along with the application. The appeal shall be listed for hearing along with the application on January 27, 2025. Pushed up. Next para. In view of appearance of the respondents to their learned advocates, as well as the short conspectus of the appeal, service of notice of appeal on the respondents, as well as calling for the records of the trial court is dispensed with. Pushed up. The appeal be treated to be otherwise ready as regards hearing. Pushed up. There shall be stay of operation of the impugned decree till February 15, 2025 or until further order, whichever is earlier. Pushed up. The respondents shall file their affidavit in opposition to the application within a week from date. Do you want to file an opposition? Don't file an opposition. That will create further problem.
I have initiated one execution case, title execution 80 of 2024.
Acha, thank you.
But the mean profits matter, this will proceed.
We'll take up the appeal for hearing on 27. যেখানে বললাম stay of operation of the সেখানে along with any connected execution case till February 15, 2020.
One accommodation. Younger sister is getting married in the first week of February.
Congratulations. Yes. Somebody else prepares the paper.
No, just date of hearing maybe.
Oh, she's getting married on 27th?
No, on 3rd of February. And there are odd rituals, my lord.
No, we'll give it on 20th then.
No,
No, somebody else has to be.
Not-
On the date of my marriage, Mr. Gupta, on the previous day, I attended court, then went to married. It was a weekend, came back. So, same applies to her also. Somebody else prepares the paper book. She'll give a temporary no objection to somebody, or she's the advocate on record.
He's the advocate.
Then no difficulty, ma'am. Get married. Congratulations.
Our younger sister is going to marry.
He's
Yes.
give a no objection and attend the marriage.
Yes.
Yes.
Matrimonial suit not filed by the husband.
We are dealing with matrimony from the morning. Yes.
Matrimonial suit filed by the husband dismissed blood on the ground that I wrote a letter blood. It's a blood on the ground that the wife has deserted. Now my application under section 9 was there initially for restitution. There the wife contested. Ultimately, an assurance was given that she will come back. I given up that suit. Thereafter, my lord, since she has not came back, the second application, my lord, for dissolution of marriage. For the purpose of proving this, my lord, that she has deserted, but I will have to, my lord, prove that I have approached to bring her back to my society. But that letter to written to him way back in 2007, please come back and reside with me. That letter is being negated by the learned trial judge, saying that since you are an advocate, you know the integrity of law. So that's why this cannot be said to be one of the evidence by virtue of which this desertion can be proved.
So you manufactured this evidence. That was the
letter
situation.
is not challenged by them also. It's no, the learned judge is of the opinion, since I know the integrity of law, that's why I have made that letter, issued that letter.
Yes. That was the purpose for the, not to manufacture evidence, but to creating evidence in a
Creating
sense.
evidence,
But
yes.
this is legitimate creation of evidence.
So that
But
ground
did she, was it considered by the court whether she had adduced independent evidence to show that she intended to come back or attempted to come?
her case, my lord, in my suit for restitution was that not she doesn't want to come back. And thereafter, verbal
What about her defense in this divorce case?
divorce case, my lord, is same. They said that mental cruelty is not being proved. My lord, it's something that we are living, my lord, separately for last 17 years. In
Yes,
any
but-
event, my lord, it's an expeditious hearing application. My lord, you
So you prepare informal paperwork
Yes,
without
yes.
comparing within 4 weeks then?
4 weeks.
In view of the implicit nature of the present, in view of the implicit nature of the, in view of the implicit urgency involved in the present appeal, which arises from a matrimonial proceeding, comma, can 1 of 2024 is allowed without any orders to cost, comma, thereby directing the appellant to put in requisites within a week from date, full stop. The trial court record be brought by special messenger at the cost of the appellant, which shall also be put in within a week from date by the appellant. Full stop. Next para. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks from date. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is otherwise ready for hearing.
Great.
Plaintiff is the appellant before your lordship, my lord. Suit for declaration and partition and consequential reliefs, my lord. That suit has been dismissed, my lord, holding, my lord, there is a wrong recording in the records of right. So the plaintiff should go to the authorities for correction of the same, and thereafter civil suit be filed. That, my lord, will find in the paragraph 59, page 23 of the judgment, ma'am. And the another point that has been ground for rejection is that actual quantum of
Page 26, what is this miss violation?
No, the memorandum of appeal, my lord. Judgment, my lord. Page 59, para 59, page 23. The long judgment, my lord.
What was the relief you sought?
Partition. And thereafter, my lord, the actual quantum of land description of the property is vague. That is
Did
the
you seek
paragraph.
for a consequential relief of correction of the records of rights?
In that event, my lord, it could have been.
Even then relevant, maybe relevant. Not a good ground, maybe, but what can you say? It's our fault, Mr.
Plaintiff.
Mr. Sen, it's our fault. Our academy's fault, judicial academy's fault, our fault. We are supposed to be the parents' patriot. No whisper of anything regarding the record.
No.
Partition
They are police.
কি রে সামন কি করছিস তুই এসব কি তৈরি করেছিস
My lord, there is an application for injunction, my lord, during the pendency of the suit, my lord. I was enjoying an injunction. And
yes need not say as a matter of right almost. A strong prima facie case for hearing of the appeal has been on merits has been made out. First of the learned trial judge, comma, in the judgment and decree impugned in the appeal, comma, has dismissed the partition suit of the appellants primarily on the ground that as per section 51 capital C of the West Bengal Land Reforms Act, comma, there is a strict bar to jurisdiction of civil courts in the matter of alteration of any entry in the records of rights, comma, which is apparently entirely extraneous to the scope of adjudication of the partition suit and an erroneous yardstick of deciding the same. Full stop, next para. In view of the averments made in the application, comma, we are of the opinion that the balance of convenience and inconvenience lies in favor of grant of injunction. Full stop. Unless an injunction is granted, comma, there is possibility of the appellants suffering irreparable injury. Full stop. Also, comma, there is urgency in the matter. Full stop. We also find from the records that the appellants had enjoyed similar injunction during pendency of the suit. Full stop. Accordingly, the respondents are restrained by an order of injunction from transferring, alienating, encumbering, and or creating any third-party interest in the suit property, and from changing the nature and character of the suit property in any manner during the pendency of the present application. Full stop. The appellant shall serve copies of the application on the respondents, indicating that the application shall be listed in the monthly list of February 2025. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date. Mr. Sen, you can take back the plaint for the time being.
My lord, I'm appearing on behalf of the respondent appellant here.
আগেকার দিন হলো এদের মানে ইয়েতে তোর খাতায় নাম উঠে যেত কি বলি বলতো কাকে বলবো বাড়িতে গিয়ে এখান থেকে বসে যে সই করে দিচ্ছে অনুযায়ী তোর ব্যাংক আমি সম্রাট ডেকে পাঠানো সিগনিফিকেন্স আমি বুঝি কিন্তু মেসেজ সই করার আগে তুমি দেখে নেবে না এটা সবকিছু চিহ্ন আছে তুই বলেছিস হ্যাঁ তুই বলেছিস not done sorry section 5 you are for the other side.
Yes,
My lord, I have not served copy, my lord, though he is a
Serve
caveat, my lord, I will serve copy, my lord.
Serve copy, come back on Monday.
My lord, the client is out of station, my lord. I have no idea regarding this type of cases, my lord.
No idea regarding
This type of cases, I
have an idea after the matter though. We can assure we will teach you. We will teach you what is the challenge against.
Give me 2 days more time, my lord.
My lord, kindly fix.
You will appear, you yourself will appear, or somebody else will.
Try my best to appear, my lord.
You appear. We will give you whatever time you want. Till when?
21st, my lord. Any days after 19th, my lord. Any days.
My lord, 17th is the date fixed before the learned trial court. They have filed an execution petition, my lord.
Oh no, then it has to be before that.
Before
Today we are on 9th. We'll spend this weekend, learn the matter. We'll keep it on Tuesday, next Tuesday.
I will serve today.
Yes.
Today itself.
The learned advocate for the appellant shall serve copies of the applications as well as a memorandum of the appeal on the learned advocate having instruction to appear on behalf of the plaintiff's respondents during the course of the day. Full stop. On the prayer of the respondents, comma, to enable learned counsel for the respondents to prepare himself in the matter, comma, the matter is adjourned till January 14, 2025. You please help him. No, help him also regarding his points. Yes.
Your Lordship, I'm really sorry. I didn't.
Yes, Mr. Korai, we did not take exception.
But I
You need to
didn't-
get worried on that. It was over then.
No, I did not mean that at all. I was personally feeling bad because what I did not mean had gone to in a different way. I'm really
No
sorry.
difficulty. Next. এটা কি? কিন্তু প্রেম মেমো রয়েছে? কোন অ্যাপ্লিকেশন? অর্ডার 41 বললেন? অর্ডার 41? ও। কোন অ্যাপ্লিকেশন ফাইলই করেনি তার মানে। এগুলো ফাইল করে ফেলে গেল, বুঝলিস? একটা টাইম দেবে তারপর ডিসমিস করে। None appears for the appellant to move the matter at the time of call, full stop. As a last chance to the appellant to appear and argue the case, the same is adjourned in January 13, 2025. সব কটা হচ্ছে ওখানে টাইম নেওয়ার জন্য ফাইল করে ফেলে। Same order. এগুলো সব রেজিস্ট্রেশন করলে রেজিস্ট্রেশনটা অবশ্য তখন তুই পেলাম।
Your Lordship, I am appearing for the respondent. Relative degree holder. My Lord, already, my Lord, we got delivery of possession last year.
What is the appeal against?
My Lord, just now I don't remember, my Lord.
Let us see.
Your Lordship, once we can file, my Lord, in course of the copy of the order also of the trial court of the bailiff report and the order of, my Lord, delivery of possession.
Oh, this was order 2197 to 101.
Yes. 5th of April 24, my Lord, the delivery of possession was handed over. My client just now has sent in.
Do this. We'll adjourn it for a day.
Right.
I mean, till Monday. You
Right.
come back on Monday, hand over those, we can
Yes.
record and
Grateful,
get.
Great.
At the time of call, comma, none appears to argue the matter on behalf of the appellant. Push up. Learned counsel appearing for the respondent submits that in the meantime, comma, possession of the property has been taken in execution of the eviction decree, comma, in connection with which the present matter arises. Push up. Learned counsel for the respondent is requested to furnish necessary documents in support of his contention on the next returnable date for enabling the court to pass appropriate orders. Push up. Let the matter stand over till January 13. We are giving you till January 14. January 14, 2025.
My Lord,
Tuesday.
one indulgence, my Lord, in place of requested, my Lord, direction, my Lordship will direct us, my Lord.
Advocates will generally direct. Next time, if you don't oblige, then we'll direct.
Grateful.
After that stricture, after that contempt.
Grateful.
Yes, next. অ্যাপিলটা ফাইল করে হয়তো ভুলেই গেছি একটা ফাইল করেছিলাম ওই সেম অর্ডার as 22 none appears last chance 13th পরেরটা 26 to এক appeal same order same
Item number 28.
I know 20, my lord. I am for the appellant, my lord. My lord, in this matter, I mean, little bit difficult, my lord. My lord, this is a change brief, my lord. Now, my lord, after going through the brief, I find that, my lord, my learned predecessor advocate has preferred an appeal against an injunction order which was already granted by the learned trial court.
in your favor
In my favor. So, my lord, I have advised my client to withdraw.
let us just check up
My lord.
Yes, exactly.
My lord. So, my lord, I have advised my client to withdraw the appeal, but my lord, I am not equipped with the written instructions.
No, we'll dismiss it on that ground. We'll make it an order of the court. What was the injunction you sought? Have you got a copy of the injunction application? Please just read out the prayer portion of that injunction.
Now, in the circumstances aforesaid, your petitioners pray that your lordships may graciously be pleased to issue a rule calling upon the opposite party to show cause as to why, during pendency of aforesaid appeal, being such and such, the respondent opposite party and its men and agents are restrained by an order of injunction from seizing and or interfering with the peaceful running and possession of the suit vehicle, being police registration number this and this prejudicial interest of the plaintiff appellant, and after hearing any cause that may be shown to make the rule absolute and to pass such other or further orders as the lordships may deem fit.
That has been granted, but subject to payment of regular EMI.
My lord,
that has to be.
My lord, that has to be when I am paying and the ad interim order is being extended.
Oh.
To the learned trial court, my lord. I do not know why the.
No, this much we can record that you have been paying the EMI and ad interim order.
Yes, my lord, your lordship can record, and till date the interim order is still subsisting. The next date before the learned, because the learned trial court is the city civil court, my lord. I have been briefed there also, my lord. The next date.
So you know, yes, you know
my
that.
lord, the next date is on 22nd January. Until then, the injunction is already there, my lord.
The matter is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. The learned advocate appearing for the appellant on change, submits in his usual fairness that in compliance of the injunction order, regular payments of EMI is being made by the appellant, and the injunction order has been extended from time to time and is still subsisting. Full stop. We find from the impugned order that by the same an ad interim order of temporary injunction in terms of the prayer made by the plaintiff appellant in the court below was granted. Full stop. Next para. Hence, it is hence, the appellant does not have any cause of action to prefer the appeal. Full stop. Next para. Accordingly, FMAT 441 of 2024 is dismissed. FMA 441 of 2024 is dismissed. তো আগেকার নাম্বার ছিল
না এফএমএ হয়ে গেছে
এফএমএ এখন পড়ে গেছে F441 হ্যাঁ
FMA 1429 of 2024 my lord FMA 1429
আচ্ছা the other way around sorry FMA 1429 of 2024 is dismissed as not maintainable. Full stop. It is made clear that the merits of the matter have not been gone into by this court, nor as to cost. We have deliberately said dismissed as not maintainable because otherwise, if we say dismissed,
well,
could be meant otherwise.
Bearing on my final hearing of the
Right.
Item number 29.
Mrs. Mr. Shokabda Roy is appearing on behalf of the petitioner. He is in court number 40. So kindly.
We are passing it over. Let him come. It's a pass over. Matter nahi karna hai.
Item number 30.
I am appealing on behalf of
Yes.
my lord.
Yes, please.
And application is now read
Oh, when did you file the can? For which court?
for this is appropriate order and or
No, not that. You had filed the can for which code? In the computer form, you have to write a code. Unless you give that number, we can't trace out. 16 itself. When did you file that application? Tell application to bar korbo. Can you please check up when it was filed?
$20th December.
20th December, it should be here. Can you just dekhe niন na? Yes. Let it be traced out. We are waiting for that application. ক্যান নট হিয়ার বলে ছেড়ে দিই খাটবে না যে রেটে চলছে মনে হচ্ছে তুই অন্যদের সময় বুঝতে পারতিস সেকেন্ড কিছু না হোক শক আপডেটটা দুটোর সময় ফিক্স করো
আপনারা যে ব্যাপারটা দিলেন না আমি যেটা ফাইল করবে ওখানে যদি
রিভাইজ করবে
স্কুপটা রিভিউ করবি আর ওই ফেস শুনবে তাহলে
ফর্মাল ডিগ্রিটা না আমিও সেটা চিন্তা করছিলাম কারণ রিমান্ডের নেচারে হয়ে যাচ্ছে আপনি ঠিক বলেছেন এটা দেওয়ার দরকার নেই কারেক্ট আমি এটা নিয়ে নিজেও ডাউটে ছিলাম তারপর ভাবলাম যে ডিসমিস তো করছি আউটরাইট মানে যদি 13B না ফাইল করে তারা রিভাইজ করবে ঠিক বলেছেন তাহলে এটা 25টা কেটে দিয়ে এটা নতুন করে টাইপ করি নোট হয়ে গেছে থ্যাংক ইউ আপনি একটু কোর্ট অফিসারের কাজে করে দিন না স্যালারি
আমরা তো হেল্প করার চেষ্টা করি
করে যাচ্ছেন তো কন্টিনিউয়াস
ভাবে না হচ্ছে যে আপনারা রিজাইন করছি কিংবা
হ্যাঁ হ্যাঁ
তাহলে কি বই আছে আমাদের বলতে
এক্স্যাক্টলি
এবার তাহলে কি হবে ধরুন আজকে আপনি একটা বই আনতে বললেন এরপরে এবার ভুলে গেল আবার
রাইট রাইট
ওনাকে বলেছি এনাকেও বলেছিস তো পড়েছে বলে মনে হয় আমরা কি ফেলে রাখলাম আমার কাছে আছে
বার করুন এক্ষুনি দিন
ওরা হয়তো মিসগাইড করছি আমি যখন পেমেন্টটা দিলাম আপনি ওদের বলেছিলাম অর্ডার সিটের বাইরে লিখে ডিগ্রি সঙ্গে জমা পাই মিস্টার সার্টেন 30%, কারণ হচ্ছে তাহলে ডিগ্রিতে তার কাছে 50%
হ্যাঁ হ্যাঁ হ্যাঁ
এবার ধরুন যেটা অর্ডারটা আমি নিলাম ওনাদের খাতায় লেখা আছে এবার ধরুন যেটা সিএবি হচ্ছে ফর জাজমেন্ট হচ্ছে প্রথমে
হুম
তো তখন যে রেকর্ড থাকে তারই নাম ওই অর্ডার সিটের সাথে লিখে রাখছে
হুম
তিনি ওই ডিগ্রিটা ড্র এটা একটু
এটা খাতায় কেন এন্ট্রি হয়নি তাহলে দেননি কেন ক্যান নট হিয়ার কেন on the days list. This is appearing for the first time. There is no caveat. Will grant interim stay and directory short form. This is arising out of a preliminary decree. The present appeal arises out of a preliminary decree of partition. Full stop. Next para. Upon hearing learned counsel for the appellant stroke petitioner, comma, we are convinced that the petitioner has a prima facie case for the first appeal to be heard on merits. Full stop. Accordingly, the trial court shall proceed with the final decree proceedings, but shall not draw up any final decree without the prior leave of this court till disposal of the application. Full stop. The appellant shall serve copies of the application bearing Can 1 of 2024 on the respondents, indicating that the application shall be listed in the monthly list of February 2025, when the appellant shall file an affidavit of service. Thank you.
My lord, I'm sorry, my lord.
Why, Mr. Mukherjee?
I had to be the respondent, my lord. I had to adjournment on the last occasion for 4 weeks. My lord, still, my lord, I have been only administered yesterday.
You have been?
Administered as regard medicine.
Oh.
He had to leave, my lord, on 23rd December.
Achha.
High pressure 198 of 108 from this our High Court medical team.
No, take care of yourself, Mr.
No, my
Mukherjee.
lord, that is why, my lord, subject to approval. Kindly allow me, my lord, 4 weeks time. And also, my lord, give me liberty to file a supplementary within 2 weeks.
4 weeks time for what?
For
An adjournment in the matter?
And 2 weeks for
You are enjoying an interim order?
No, interim order with status quo, it was disposed of as regards status quo.
Oh, this is a hearing of the appeal.
Appeal.
Oh.
4 weeks, suit in
Mr. Mukherjee, let it be a bit less.
Last occasion,
They are also
Why not?
suffering, not
Yes.
4 weeks.
Yes.
They are suffering also, not 4 weeks.
Well,
Prepare yourself.
If not recover, my lord, if senior learned senior friend not
don't just do so.
Mr. Mukherjee, if you have any difficulty, either you prepare yourself or you prepare in any of your competent juniors and let him move the matter.
No, with this in short time, because I could not think of it. This will take only, my lord.
You could not think that the appeal would be taken up for hearing so fast.
As regards my health, because I never thought of it.
Mr. Mukherjee, I mean, please take care of yourself, but please make alternative arrangements then, because the respondents cannot be made to suffer. This is not something personal against you.
No.
Because we revere you. You are quite a senior advocate, Mr. Mukherjee.
If he wants to get that in that hyper
Because,
way,
no, his client is suffering.
At the opposition, serve me copy on 2nd January.
Mr. Mukherjee, let us make then alternative arrangements if you can't appear in the matter.
Yeah.
4 weeks is too much. We can take it up on 20th of January or 27th of January at the best.
27th.
Today we are on 9th. 27th gives you more than 2 weeks.
The supplementary paperwork will have to 2 weeks will suffice.
We'll give you 2 weeks. Prepare the supplementary affidavit, give an advance copy to them, and we'll keep it after that.
So your lordship is keeping it on 27th.
28th, we are keeping it.
29 can it be?
If you knew you'd say 29, we'd start with 24th.
No. What is the 29th?
29th is a Wednesday.
Wednesday.
It's a Wednesday, yes.
Can it be done 29th?
Learned counsel appearing for the appellant seeks an adjournment on the ground of his ill health. Full stop. Next para. On the prayer of the learned counsel for the appellants, comma, the appellants are directed to file a supplementary paper book incorporating the omitted relevant documents. The same shall be prepared within a fortnight from date with an advance copy on the learned advocate for the respondents. Full stop. The appeal shall be listed for hearing next on January 29, 2025.
And one thing, my lord, at the time of hearing, if I feel some inconvenience, kindly cooperate with me.
Mr. Mukherjee, why don't you make alternative arrangement? Why take the risk? Make alternative arrangements for this.
Because we
can permit you to
sit. Conducted the case, my lord.
Mr. Mukherjee, we can permit you to sit and argue.
No. In the lower court, they conducted the case, so they have more well conversation with the matters of record. But my matter is.
Mr. Mukherjee, we do not want to compel you, despite your ill health. Do it, but it has to be done because we don't have any assurance.
I will get it.
Otherwise, get some able assistance with you. You move the matter. You move it while sitting on a chair. have some assistance, we would cooperate in every
I'll-
manner.
I'll-
But the matter has to be done. We
I
are
will do.
giving you more than 2 weeks time.
Yes, yes.
We'll come back in 5 minutes for the next one. Pass over na pass over.
One Malad
Yes.
guidance, item number 31, and if the lordship finally direct them to send the lower court records.
Mr. Mukherjee, since they are not there, we won't pass any direction.
He told me that if it is possible.
No, no, no.
to both
No,
of
no.
them. Oh, other side. Then should I,
Whenever it is called on next time. Trial court records are not here.
trial court record is not in the department. So only from, it is in court. So if trial court record is sent, so that I can.
It is in the department or in the court?
In this court.
In the department of this court?
In the department of the trial court is no. Trial court is in
They'll
court.
check up.
Yes, yes, I have been told because we wanted to take so that we could have been prepared. They said the lower court record is there.
Are here, yes.
Yes. So if it is sent to the department.
No, Mr. Mukherjee.
Oh, all right. I'm.
Yes.
For the appellant lordship led by Mr. Raghunath Chakraborty, kindly make it not this
No,
week,
no, no.
lordship.
Sorry, refused. On the last occasion also you prayed for adjournment.
I didn't appear that time.
No, no.
Notify the other side also on second.
You have served a notice on the other side.
Yes, lordship.
Where is that notice? We are passing it over. If it does not come, we'll dismiss it for default. Pass over. পাস ওভার গুলো যেরকম অর্ডারে পাস ওভার হচ্ছে সেরকম রাখবেন আগের যেটা পাস ওভার হচ্ছে সেটা লাস্টে সব হয়ে যাওয়ার পর
Volta, 33. 33.
Item number 33.
Line.
Yes, sir.
Dismissal of a matrimonial suit by the husband.
Mr. Chakraborty, can it be finished by today? What is the point involved?
Point involvement, mainly I have to place the pleadings, entire pleading matter is dependent on entire pleading because and judgment is quite longish and some.
Then we'll take it up on next month.
These are dealt with some point extraneous things.
No, if you have to place, you have to place. Since the hearing of the matter will require some time, and as this is not the regular bench, let the matter stand adjourned till January 13, 2025, when the
Kindly make it 14. Monday.
January 14, 2025. Push.
Okay.
But I beg to appear on behalf of the appellant.
I appear for the respondent.
For specific.
What is the matter about? Can we do it today?
Yes, it's a
Very
matter
good.
of minute. my lord.
Excellent. Fair enough on both of you. Yes.
For specific performance, agreement, content, and arbitration clause, their predecessor filed the written statement. Thereafter, they filed another written statement. The written statement was accepted. I have annexed all those. Along with the second written statement, my lord, they filed say, application under section 8 of the arbitration and conciliation.
Paperbook ko hai?
My lord has directed that paperbook not essential because
Yes,
all
right.
papers are here, my lord.
So what was done? The suit was dismissed.
Then suit was dismissed. My lord, my demand around two premise. One, the application under section 8 was filed after the written statement was filed, so it cannot be. They have already submitted to the jurisdiction of the honorable court, and even then, even if I take their case,
Could not have been dismissed. Could have been referred to. Yes. What do you say?
It has not been, it has dismissed and liberty is granted to refer to arbitration, my lord.
No. Suit has been dismissed.
Kindly see the order once.
We are at the order. See the ordering portion.
May I?
Present suit is dismissed at this stage. What is dismissal at this stage?
No.
We are allowing the appeal at this stage, Mr. Bhatt.
Kindly come see 84A. The present petition allowed suit is dismissed at this stage in view of the above finding. The parties are at liberty to raise the dispute.
Read the second sentence slowly. The present suit is. Read it very slowly.
The suit is dismissed at this stage in view of the above.
So we are allowing their appeal at this stage.
may I state the written statement? These
Mr. Bhattacharya,
I'm not.
you lose on both grounds. First of all, Section 8 criteria are not fulfilled. You filed that application with your second written statement. So under Section 8, you have to file it before or with your first statement on the defense of the case, merits of the defense, which you have not done. So Section 8 is gone. And in any event, suit could not have been dismissed. We will set aside this, remand it, direct the trial court to hear it on merit and decide it.
In the written, that I bow down to it. Only, my lord, in the written statement, we have taken the preliminary objection regarding the arbitration clause. There was a specific statement in the written statement itself, my lord.
Show us that.
Kindly comes to kindly comes to page 40, 49. 49. Page 49 of paragraph 12.
This is not an application under Section 8.
In the written statement, we have taken
Even in the written statement, this is not within the contemplation of Section 8. Section 8 says, so applies. If you so apply, then the court may refer parties to arbitration. In para 12, we have not applied for it being referred to arbitration. You have taken an objection as to jurisdiction, which is not maintainable in law, unless you file a second. And this is your second written statement.
No, first written statement.
With the second written statement, you filed a Section 8 application.
No, we have not we have filed a Section 8 application after the written statement was filed.
Now, my lord.
No, Mr. Bhattacharya.
Only these 2 points, my lord, and they have also annexed the agreement for which they have filed for specific purpose.
We won't go into that. You have waived your chance when you file your written statement.
May I read a judgment of?
Absolutely, please do, because you are going to allow their appeal.
No. There is a unreported judgment of Delhi High Court, my lord. আমি দিয়ে দিচ্ছি, copy দিচ্ছি তোমাদেরকে। Kindly, it's downloaded from the
no difficulty.
Kindly comes to page 14. My 14 is in the bottom side, my lord.
All right. Yes.
Paragraph 41 onwards.
Right.
So and so, therefore, examine in details that the issue of specific application or even a request to refer the parties to arbitration is a non-negotiable prerequisite for Section 8(1) of the 1996. The issue was answered negative, specifically holding that it matters not that counsel for while drafting written statement, instead of using refer to the parties to arbitration, use the word the court lacks jurisdiction to entertain and decide the suit in view of the arbitration agreement.
Like your case, like your arch.
It is obvious that this passage was not obiter dicta as so and so in Rashtriya Ispat Nigam would seek to urge, but clearly constitute the ratio decidendi of the concerned decision in the right of the judgment or division bench and so, and no objection of so and so predicted in para 12 and 18 of Shukarna holding cannot sustain. The third reason why the objection of so and so cannot be accepted is to be found in paragraph para 16 of the judgment of the 7 judges constitution bench of the Supreme Court in so and so. We may at this stage notice the complementary nature of Section 8 and 11, where there is an arbitration agreement between the parties and one of the parties ignores it, files an action before a judicial authority, and other party raises the objection that there is arbitration clause. Judicial authority has to consider the objection if the objection is found sustainable to refer the parties to arbitration. The expression used in this section is shall, and this court in so and so and so has held that the judicial authority is bound to refer the matter to arbitration once the existence of valid arbitration clause is established. Thus, the judicial authority is entitled to and has to take bound decision, decide the jurisdiction issue raised before it, and making or declining to make a reference. Para 16 of the decision and so holds unequivocally that where there is the ignorance of the arbitration agreement between the parties, a suit is instituted, opposite party raises an objection as predicted in so and so, the court is bound to, if the objection is found sustainable, to refer the parties to arbitration. This statement of law completely covers the present case. Now, ultimately, my lord, the matter was referred.
Mr. Bhattacharya, have you brought those judgments, Rashtriya Ispat Nigam and
No,
because
though
this is the Delhi High Court's view on those judgments.
Yes, and ultimately has referred this matter in view of the past.
No, what this is the Delhi High Court single judge's view. We are have you brought because this is the interpretation of Delhi High Court that was not obitur dictum in that. Now, have you brought those judgments? Because
I am ready to bring.
No, your readiness won't do. Then bring it at 2 p.m.
My lord, even then.
No, we'll come back to you.
But,
Let him finish. Let us see the previous paragraphs. In the court. What is Sharad P. Jagtiani? That is relied on by the Delhi High Court. Where has that been discussed in the judgment? The court relies on the judgment of Sharad P. Jagtian in this. It was a division bench judgment of the Delhi High Court.
My lord.
This only has persuasive value, Mr. Bhattacharya. Anyway, this has some value, so we'll look into it. Let us see, please come to para 37, where this Sharad P. Jagtiani judgment division bench of Delhi High Court was considered. স্টেটমেন্ট জুরিসডিকশন চ্যালেঞ্জ করে তাহলেও সেকশন opinion, prima facie, so we are putting it to you so that you can dispel our view. We tend to differ with respect from the Delhi High Court view. The Delhi High Court equates an objection as to jurisdiction of the civil court in the written statement with a prayer under Section 8. Our difference is on this. Section 8 is a waivable section, right? This objection, it provides you a right to take an objection that please refer the matter, the civil court, please refer the matter to arbitration. If you don't make that prayer, the civil court still retains jurisdiction and it will hear out the matter. So if a particular right can be waived, it's not an absolute bar on the court's jurisdiction. The civil court never loses jurisdiction. Civil court retains jurisdiction all along. Even if the matter is referred to arbitration, civil court has jurisdiction. Therefore, we think it's a different proposition to say that the civil court, you don't have jurisdiction because of existence of an arbitration clause, and to say that civil court, please refer the matter to arbitration. These are two different aspects. Therefore, we tend not to equate an objection as to jurisdiction of the civil court, which is not sustainable in law actually, unless you seek a reference. And a reference, an application seeking reference, even if in the written statement, Mr. Bhattacharya, your client said that the matter ought to be referred to arbitration, we can understand. That would be broadly within the contemplation of Section 8. We could be very liberal on this, and Section 8, we would incorporate the principle. Here you say you don't have jurisdiction. But if you don't file an application or pay for a reference to arbitration, the civil court does have jurisdiction. So it is possible for the civil court to say, yes, I have jurisdiction. And at the same time, if you file an application for reference, to say, yes, I have jurisdiction, but I refer it to arbitration since there is an arbitration clause. So therefore, we don't tend, we differentiate this issue on this point. We distinguish the Delhi High Court's judgment on this point. And in any event, it was the learned single judge of the Delhi High Court, but we respect the opinion of the learned single judge. The learned single judge interpreted a judgment of the Delhi High Court division bench. We have also seen that judgment quotation. We are of this opinion. What do you say?
Only two things, I am bowed down, my lord. In 2003, 5 ACG, Shukonna holding, my lord, this point was specified that if we, before written statement, if we do not file Section 8, then Section is not maintainable. But here, my lord, only I have found this judgment, my lord, where the Shukonna Holdings judgment was distinguished, and thereafter, because here Section 8 was not filed also. Here, my lord, only written statement was filed stating that there is...
No, we could, no, Shukonna Holdings held that you have to file a Section 8.
Section 8 before filing of written statement. That was a Supreme Court judgment which says that Section 8...
Is there any subsequent Supreme Court judgment which says otherwise?
I could not find.
Then the Shukonna Holdings, as far as we know, that is the last proposition of law.
That is 2005.
Therefore, the Delhi High Court is also, with utmost respect, erroneous on that ground.
Delhi High Court has said here in this judgment, which I have referred, my lord, no Section 8 application was filed. Only objection was filed.
Therefore, the Delhi High Court deviates from the Shukonna Holding proposition.
And thereafter,
that is the difficulty. So this judgment is par inquirium.
But he has referred the Shukonna Holding.
Referred, yes.
Even that judgment which my lord has referred.
No, not later than the date of submitting his first written statement. First statement, we may be liberal on that. We could have been liberal on that. Not before may meal simultaneously with the first statement. Anyway, and the other point remains also that the court could not dismiss. But even then, this we can't equate this with an application under Section 8 because you never seek a reference to arbitration.
No.
Sorry, Mr. Bhattacharya.
We'll
remand it to be heard on merits.
The preliminary issue will be framed by the court.
Issue as to what?
That whether this suit is or the maintainable, since there is.
We'll hold from here that the suit is definitely maintainable. Because your jurisdiction ground is challenged only on arbitration agreement existence. We are of the opinion that is the premise on which you distinguish the Delhi High Court. This does not pertain to the jurisdiction of the court.
I review to Lordship.
Yes, what do you say?
We tried to take a holistic view without prejudice to our appeal. After that,
holistic means to find a hole or hole in their argument.
My lord, after this appeal was preferred and when it was pending, my lord, we issued a notice, my lord, without prejudice to our rights and contention under Section 21. Till date, no reply has.
You have given a notice. If both of you agree,
without prejudice after the appeal, during the pendency of the appeal, so that the things could be sorted out. It's a old suit, my lord, old.
If you can agree to an arbitrator, we can.
I'm still ready and willing to. Even my lord, subject to correction by your lordship, moderately mid-level or junior member of the bar may take.
No, we are not exercising Section 11 jurisdiction. You have both of you have to agree to that then.
Yes, that is why I requested.
I have no instruction to that.
You are seeking arbitration, reference to arbitration.
My stand is, my lord, that is civil suit is not. If we have, they may prefer application. They may prefer application under Section 11 because the.
No.
You are saying that civil suit is not maintainable, and in the same breath you are disagreeing to. We'll record that, Mr. Bhattacharya. No, we are not threatening you. We'll actually record this. Whatever is transpiring in court, we'll record, and we'll add this as a further ground.
Let it be referred to civil court. Let it be adjudicated there, my lord. Because
so we'll record that they are agreeable to appointment of an arbitrator, but you are not.
Let it be referred to civil suit, my.
And we'll be recording that also. As per previous direction, the appeal itself is taken up for hearing. Application is still pending.
No, this application.
The application is
pending.
Along with the application.
Application pending.
The present appeal has been preferred by the plaintiff in a suit for specific performance.
Yes,
for specific performance, by the impugned judgment and decree, the learned trial judge. What application was allowed? Your Section 8. The learned trial judge, simultaneously with allowing an application of the respondent stroke defendant under Section 8 of the Arbitration and Conciliation Act 1996, dismissed the suit itself. Learned counsel for the appellant argues that even Section 8 of the 1996 Act does not contemplate a dismissal of the suit, but merely speaks about reference to arbitration. Next para, that apart, the defendant stroke respondent did not take out any application under Section 8 of the 1996 Act, either simultaneously with or prior to filing of the written statement, which was the first statement on the merits of the defense within the contemplation of Section 8 of the 1996 Act. Hence, in any event, the application under Section 8, filed subsequent to the filing of the written statement in the court below, ought to have been dismissed by the learned trial judge. Next para, learned counsel appearing for the defendant stroke respondent cites an unreported judgment of a learned single judge of the Delhi High Court in the matter of Madhusudan Sharma and others versus OMAXE Limited. In the said judgment, the learned single judge of the Delhi High Court, by relying on a previous division bench judgment of the Delhi High Court in the matter of Sharad P. Jagtiani, arrived at the conclusion that even if an application under Section 8 of the 1996 Act was not filed, but a preliminary objection as to jurisdiction of the civil court on the ground of existence of an arbitration clause is taken in the written statement, the matter ought to be referred to arbitration. Next para. Upon a careful consideration of the arguments of the parties, we are of the opinion that the impugned judgment is bad in law on two very important counts. First, even if an application for reference to arbitration under Section 8 of the 1996 Act was to be entertained by the learned trial judge, the suit could not have been dismissed as a whole. The matter only ought to have been referred to arbitration. Next para. More importantly, in the present case, the defendant stroke respondent took out an application under Section 8 only after filing of the written statement, thereby defying the mandate of Section 8 itself. Section 8 of the Arbitration and Conciliation Act 1996 is quoted below for the purpose of convenience. Section 8 take to the next para. A bare perusal of the said section clearly shows that a judicial authority can only refer the matter to arbitration in view of the existence of an arbitration agreement stroke clause if the party seeking such reference applies for such reference not later than the date of submitting his first statement on the substance of the dispute. Full stop. The first statement on the substance of the dispute in case of a civil suit is without doubt the written statement filed by the defendant. Full stop. It is an admitted position that in the present case, comma, the application under Section 8 of the 1996 Act was filed after the filing of the written statement, and as such, comma, the provision of Section 8 could not have been invoked by the learned civil judge. Full stop. Next para. Another limb of argument of the defendant respondent is that in paragraph number 12 of the written statement, comma, the defendant pointed out that the civil court has no jurisdiction to entertain the suit in view of clause 22 of the agreement dated May 28, 1993, and as such, the same should be dismissed. Full stop. It has been argued by the respondent that clause 22 was an arbitration clause, and as such, comma, paragraph number 12 of the written statement should be construed to come within the purview of an objection taken under Section 8 of the 1996 Act. Full stop. With utmost respect, comma, we are unable to express our agreement with the view taken by the learned single judge of the Delhi High Court in this context. Full stop. It was specifically held by the Supreme Court in the case of আপনি সুকন্যা হোল্ডিং লিখে রাখুন। হ্যাঁ, আমি নাম সাইটেশনটা পরে দিয়ে দেবো।
2003 5 SCC
থ্যাংক ইউ ভেরি মাচ।
531
একটু লিখে রাখুন 2003 5 SCC
531
531 in Sukonna Holdings Private Limited versus such and such, reported at such and such, that an application under Section 8 has to be filed before the filing of the first statement on the substance of the dispute. Full stop. Next para. Thus, comma, the view taken by the Delhi High Court is contrary to such proposition. Full stop. Next para. Moreover, comma, on the other aspect as to whether an objection in the written statement as to jurisdiction of the court can be construed to be an application under Section 8, comma, we also are unable to agree with the arguments of the respondent. Full stop. There is a gulf of difference between an objection that the civil court does not have jurisdiction to entertain a suit and the suit should be dismissed on such ground, and an objection that the subject matter of a civil suit, comma, being also the subject matter of an arbitration agreement, comma, ought to be referred to arbitration. Full stop. Section 8 contemplates a provision for reference to the to arbitration of a dispute regarding which there is an arbitration clause and does not operate as a bar to the civil court's jurisdiction. Full stop. Even if a reference is made to the arbitrator, comma, the civil court does not lose subject matter jurisdiction. Full stop. It is only by operation of Section 8 that the civil court has to refer the matter to arbitration. Full stop. Next para. Hence, comma, moreover, comma, the provision of Section 8 contemplates a bar, comma, if at all, comma, which can be waived by the parties. Full stop. A bar which can be waived is not an absolute bar on the jurisdiction of the civil court, coming within an express or implicit bar as contemplated in Section 9 of the Code of Civil Procedure. Full stop. In the event no application for reference to arbitration is made, comma, the civil court can very well entertain a suit and proceed with adjudication on the same on merits in accordance with law. Full stop. Hence, comma, we do not find that there is any bar to entertain the suit implicit in the existence of an arbitration clause in the concerned agreement between the parties. Full stop. Thus, comma, the objection taken in the written statement in paragraph number 12 thereof regarding the civil court not having jurisdiction even to entertain the suit and seeking dismissal on the suit of such ground is completely different from seeking a reference under section 8 of the 1996 Act. Full stop. Hence, comma, we cannot, comma, under any stretch of imagination, comma, equate such an objection taken in the written statement as to jurisdiction seeking dismissal of the suit with an application to refer a matter to arbitration. Full stop. Thus, comma, on the said point, comma, we humbly express our disagreement with the view taken by the learned single judge of the Delhi High Court in the cited judgment. Full stop. Next para. In view of the above discussions, comma, the learned trial judge committed a patent error of law on both counts. Full stop. First, comma, the suit could not have been dismissed even under section 8. And secondly, comma, the section 8 application having not been filed before or even simultaneously with the written statement of the defendant, comma, could not have been entertained at all by the learned trial judge. Full stop. Accordingly, comma, FAT 308 of 2023 is allowed on contest, comma, thereby setting aside the impugned judgment and decree. Thereby setting aside the impugned judgment and decree. Details. Thereby setting aside the impugned judgment and decree dated April 21, 2023, passed by the learned civil judge, senior division, 3rd court at Alipur district, South 24 Parganas, in title suit number 110 of 2017, within bracket serial number 84 of 2017, bracket closed, and directing the trial court to take up and decide the suit on merits upon full-fledged trial. Full stop. The application under section 8 of the Arbitration and Conciliation Act 1996 by the defendant respondent in the court below is stands hereby dismissed as well. Full stop. Next para. However, comma, we make it clear that we have not gone into the merits of the counter contentions of the parties in the suit, and it will be open to the learned trial judge to independently decide all issues involved, comma, except the issue of maintainability of the suit on the ground of jurisdiction due to existence of the arbitration clause. Full stop. Next para. Can 1 of 2023 is also disposed of accordingly. There will be no orders to cost.
Title suit number 1110. My lord, may you find at page 57 or
But the impugned order says 110.
it has been stricken out and then written above 1110. It was initially written 110.
In the copy of annexed with the
Yes, page 82A.
let us see the certified copy once.
Decree is 1110.
We'll check the certified copy. Yes, in the certified copy it is correct. Hello, 110 বলেছি 1110. But in the copy annexed with the stay application, that striking out is not there.
So that has been corrected in the decree.
Yes, yes, in the decree it is correct. We saw page 83 actually, but before that in the cover page it's corrected. Anyway, 1110 of 2017. However,
And my lord, with regard to the Delhi High Court judgment, what what prompted to the learned single judge, since there was an application under order 37, and there the defendant filed an objection to that, he treated the objection with regard to arbitration agreement on the basis.
No, but the Delhi High Court proceeded on the premise that an objection as to jurisdiction due to existence of arbitration clause can be equated with section 8. We have to distinguish that also.
Yes, absolutely.
But you have found out this judgment is a very relevant judgment. Thank you.
Great.
ভালো মামলা ছিল। হ্যাঁ। ভালো।
For the respondent number.
What is the appeal against? Injunction.
Injunction.
Modification of injunction order, suit for partition filed against me and others 40. My construction was started before filing of the suit. Thereafter, he filed this suit against me and others 40. The first, initially, the status quo order was given. Thereafter, the changed circumstances is that I have not obtained sanction plan. Subsequently, a substantial plan is obtained, and I made a modification.
You obtained sanction plan during pendency of the suit.
During pendency of the suit.
But there was a status quo then.
Status quo the but
how could you obtain the sanction plan? You had applied for the sanction plan before the injunction.
Before that injunction, but there was it was issued.
So you sought a modification to what effect? That you may be permitted to construct.
Permitted to construct, my lord. That incomplete construction is there only only.
Let us see the impugned order.
Impugned order was refused only on the ground that there is no sanction plan.
One thing, my lord, I take plenary objection regarding the documents is concerned. One of the purported sanction plan issued on 7/12/2023. Probably is it?
এইটা আরেকটা আছে যে 342 আছে যেটা 320
And no,
What is the impugned order? Which page of the paper book?
probably it was not there.
impugned order is page number
Must be there with the memo.
Yes.
Yes, no.
Page number 12, my lord. 11.
Yes, 12 it says no sanction plan.
As it's undisputedly, I have been uninterruptedly, I am in possession since 97, and before that, when my predecessor was died, and I inherited the property, and subsequently, some property has been purchased in 97 also. Since then, I am possessing and enjoying uninterruptedly and undisputedly.
No, even independently of that, Mr. Shatra, page 12, the court says in the second last paragraph that at the time of hearing, defendant number 1 has not produced any document regarding sanction plan from any local authority relating to permission. Even independently of that, the court proceeds to deal with your judgment and holds that temporary injunction was passed for protection and preservation of the suit property if you are permitted to raise construction whimsically without the permission or without the permission.
Yes, my lord.
So you say that the sanction plan was not looked into.
At that time, it was not produced before the court, but it was obtained. But
Then there is no mistake in the order. You obtained it after this order.
No, before this order is
But could not be
It was
produced.
not produced before the court when the hearing was made actually.
Even independently, Mr. Shatra, even if you produce the sanction plan, could not make any difference because it was obtained after the status quo order was passed.
Yes, that has been obtained, but it was
That you took a risk. That will be sub judice. I mean,
before filing the suit, all the malified intention he has been filed.
We cannot reopen the original injunction order in order 13/4. Was the order the ad interim injunction? You sought a modification of the ad interim injunction, right? Contested then
Only those two parameters, and this point was taken.
But before filing of the suit, only the malified intention. He has no land in the das property. His predecessor already sold out.
One is that he has to suppress something. Suppression is one of the grounds, or probably change of circumstances is a ground.
Undue hardship, change circumstances.
No, just
Change circumstances.
No. If it is a contested hearing, then it's further limited.
Preliminary 12/2020
Order
was
13/4.
contested and disposed. Subsequently,
Provided that if an application for temporary injunction or any affidavit supporting to such application party.
No, let's see the second proviso.
Yes, second proviso. When an order for injunction has been passed after giving to a party an opportunity to be.
Yes. Change of circumstance, undue hardship.
So this was there. The defense was taken regarding the construction, and it was found to 2021 the construction started. If that is taking into account my learned friends, so the
2021
construction started. Order of injunction was passed. Commissioner went, found the construction is going on.
When was the injunction passed?
2022. Initial order of status quo was passed.
11 March 2022.
11 March
2022. And my lord, I'm drawing.
The injunction application itself was disposed of on that date.
On that.
Suit was filed January 2021. Before that, my construction was started.
Yes. Then, my lord, according to page 49, in spite of the order of status quo, this was inspection was held, page 49.
After starting my construction, he purchased the property and subsequently he filed this suit.
This 2021, if your lordship may kindly turn to, I am drawing lordship attention to answer number 3, as per direction number 3, that is at page 50. Before that, an interim order was passed. Construction was going on. So after that, contestant same objection was taken in the written objection.
That was dealt with.
That was dealt with. Now, my lord, if today the sanction plan was obtained after passing of the order of status quo and violation of the order of injunction that was going on, then whether, my lord, by granting such permission, because, my lord,
this local inspection was held before the status quo was made absolute. Because the initially identity status quo was passed.
After the local inspection, final order.
Final order was passed on in 2021, 2022, 11th March 2022. You have taken this point. This was turned down by the court.
Local inspection, in the local inspection, there is several construction and permanent house is there in 342 Dagnamati 42. But my possession also undisputedly I am enjoying and possess since.
This is a partition suit.
This is partition suit, but who possess only 1 point something decimal, who has not injuncted the whole of the property, where the others 20 or 30, 40 members is co-sharer is there.
Page 52, my lord, why the objection was there? There is no dispute over the other owners are concerned. Can you turn to page 52?
Even the plaintiff has not that no possession is also there. I am
What he has done, my lord,
possess the property
and
and
the entrance in the both the sides, left hand side and right hand side. He started construction over these two portions.
Where is the original status quo order?
Yes. Order to this.
You must have a copy of it.
If your lordship can turn page 120.
74 pages. 128. 74. Original
74.
11/3/2022 74.
74.
Thank you.
Eleven 3/2022 তার আগে ডক্টর হ্যাঁ আমি ঠিকই তো বলেছিলাম পেজ 120. That is the disposal order, my lord, not the injunction, which my learned friend is pointed out to your lordship.
Final order.
That is a final.
Yes, that is what we are wanting.
No, my lord is asking the additive order of injunction.
No.
Oh, final order. That point was taken. Construction was going on.
Where is your order 39 rule 4 application? I have not given page numbers in the index.
Page 82.
70. 70.
No, it is application. Application is, my lord, page 78. 78. I beg to it. That is our objection. 78 is the application.
78 is application and relevant page 79.
Yeah.
Paragraph 4.
Right.
Not see. CPC 13.
But Mr. Shantri, no additional hardship has been pleaded by you, apart from your building materials rotting there. I mean, rod, cement, নষ্ট হইতেছে. This is your case.
And also the what construction has been given. Kindly go.
No, that we cannot reopen the injunction order on merits because we are not hearing an appeal against the injunction order. Order 13 Rule 4 is very limited. No,
construction has been started. The floor also is there. The pillar and floor also there. That has been damaged.
No, no, keep it with you. If it is not a part of the trial court
construction has been made, the basement actually, the basement has been constructed. All the.
But that is not there in your application.
Apart from that, 2021 construction started. 23 plan obtained.
Para 4. When did you obtain the sanction?
গৃহ নির্মাণ কার্য প্রায় লিন্টন লেভেল পর্যন্ত হইবার পর লোকাল ইন্সপেকশন রিপোর্ট such and such হুজুর আদালত নিষেধাজ্ঞা.
You only say the building materials are decaying.
গৃহ নির্মাণের কার্য বন্ধ হয়ে আছে, ওই মতো গৃহ নির্মাণের বিল্ডিং মেটেরিয়াল অর্থাৎ রড, সিমেন্ট ইত্যাদি নষ্ট হয়েছে, সেই কারণে অধীন অসমাপ্ত গৃহের ঢালাই ছাদ সহ বসবাস.
You have not said that the construction made is decaying. You have said the building materials are decaying.
From the local inspection, it is said that there is some pillar. 12
give us three. The suit was filed on 25th of January 21. On that date itself, ad interim status quo was passed.
Yes, my lord.
Yes.
What status quo? Injunction order was final.
27/1/2021.
27/1 or 25?
27 January 2021. And initial edited order injunction was passed by
injunction or status quo.
Status quo. My lord, the injunction.
11th of March 2022, injunction order was passed.
Contested. That is the contested.
11th March of 2022, the contested final injunction order was application was disposed of. And when did you obtain the sanction plan?
2023.
15 March 2023.
No, subsequently obtain a sanction plan does not give you any further right.
But in the village that the pillar has been started, the application has been made. Application was made thereafter doing the process.
Even in the village, you cannot flout the law. It may be easier to flout the law, but you cannot.
But there is another 40 co-sharer is there. They are interested.
We cannot reopen the injunction application. This is you are trying to re-argue the merits of the injunction application, which is not permissible in Order 13 Rule 4. We are hearing an appeal against an Order 13 and Rule 4 order. So it's like a cylinder. Whatever powers the 39(4) had, we have. We cannot go beyond that and look into the original injunction order on merits. This argument of yours that there are 40 other co-shares, he is the owner of a minuscule share. That itself that cannot be reopened in Order 13 and Rule 4. Because that's on the merits of the main injunction.
But one person, one co-sharer who has leased.
Don't repeat, Mr. Shantri. We have heard it. We have addressed you on that.
The only malified intention and mal motive is file a suit.
Beyond the scope of 39.
But we are in possession in 1997 and before that. From the
impress the trial court. Yes. Impress the trial court in the suit. Shubhesh.
At least one. Suit may be disposed only at this limited period. That also.
What is the stage of the suit?
They also not.
What is the stage of the suit?
They also not served the others 40 members also. 40 others defendant.
Then how can you direct that?
This is the intention. That's filing the suit. They have also started the process also. The suit was filed in the 2021. Several direction was there.
Let us see.
That's order sheet also.
The present appeal has been.
Several direction also there, but not.
The present appeal has been preferred against an order whereby the application filed by the defendants appellants under Order 39 Rule 4 of the Code of Civil Procedure for modification of an injunction order was dismissed on contest. Push up next para. Learned counsel for the appellant argues that although the defendants appellants had started construction much prior to the institution of the partition suit, by virtue of the injunction order, the said construction has been stopped, comma, thereby resulting in the building materials and the construction partially made decaying. Full stop, next para. It is argued that the plaintiff stroke respondent, plaintiff is respondent number one.
Yes, ma'am. No, plaintiff is respondent number one.
Yes,
The defendant number one applicant.
Very well. That the plaintiff stroke respondent numbers one and plaintiff stroke respondent numbers 1 and 2, comma, who are the owners of a minuscule share in the property, comma, are holding the interests of over 40 co-sharers at ransom. Full stop. It is argued that the injunction order restraining all the defendants from making any further construction is not commensurate with the minimal shares claimed by the plaintiffs. Full stop, next para. Learned counsel for the respondent numbers 1 and 2, who are the plaintiffs in the court below, and the primary contesting respondents, comma, argues that the points now sought to be raised before this court were substantially urged before the learned trial court at the time of disposal of the injunction application. Pushed up. That apart, comma, it is pointed out that the sanction plan pleaded to have been obtained by the appellants was not produced before the trial court. Pushed up. Moreover, comma, it is argued that even as per the appellants, comma, the sanction plan was obtained in the month of March 2023, comma, that is after the injunction order was passed on contest, and as such, comma, ought not to be looked into as a change of circumstance. Full stop, next para. Upon hearing learned counsel for the parties, comma, we find that the scope of Order 39, Rule 4 of the Code of Civil Procedure, insofar as it pertains to vacating and or modifying an injunction order passed on contest, comma, is limited by the second proviso to the said provision. Full stop. The said proviso stipulates that when an order of injunction has been passed after giving to a party an opportunity of being heard, comma, the order shall not be discharged, comma, varied or set aside on the application of that party, except where such discharge, comma, variation or setting aside has been necessitated by a change in the circumstances, comma, or unless the court is satisfied that the order has caused undue hardship to that party. Full stop, next para. The hardship now complained of by the appellants was available even at the juncture when the injunction order was passed on contested hearing on March 11, 2022. Full stop. In the guard of entertaining arguments of the defendants' appellants to the effect that the plaintiffs own a small share in the property but are holding the majority co-sharers at ransom, comma, the same would tantamount to adjudicating, the same would tantamount to sitting in appeal over the contested injunction application passed on March 11, 2022. Full stop. The scope of Order 39, Rule 4 of the Code is not cannot be equated with that of an appeal under Order 43 of the Code against an injunction order, and as such, comma, we are unable to entertain such arguments on the merits of the injunction application. Full stop. Insofar as change of circumstance is concerned, comma, the defendant's appellants cannot take advantage of that own wrong. Full stop. At the juncture when the impugned order was passed, comma, no sanction plan was produced. Full stop. Even if we construe such omission to be a bona fide error on the part of the appellants, comma, the sanction plan was obtained only on March 15, 2023, comma, not only during pendency of the suit, but about a year after the contested, about a year after the injunction application of the plaintiffs was disposed of on contest, thereby granting injunction restraining the present appellants from making the construction. Full stop. Hence, the subsequent sanction plan obtained by the defendants appellants after the passing of the injunction application, contested injunction application, sorry, after the passing of the contested injunction order, cannot be used as a handle to give an additional premium to the defendant's appellants, nor be construed to a change of circumstance. Full stop. Next para. As such, we are of the opinion that the parameters of Order 39 Rule 4 were not satisfied in the present case. Full stop. That apart, we find from a perusal of the impugned order that sufficient reasons have been provided by the learned trial judge while doing so, while passing the same. Full stop. The learned trial judge had observed that the page of the impugned order, Mr. Chan, page 11.
11.
Thank you. Observed that the instant suit has been filed by the plaintiffs praying for partition of the joint property, and the plaintiffs have established a prima facie case to go for trial. So it was further observed that if the defendant number 1 is permitted to raise construction whimsically on the joint property without the permission of any appropriate authority and without the sanction plan of the local panchayat authority, the plaintiffs will be prejudiced and the object of the temporary injunction will be frustrated. Full stop. Even if we take into consideration the sanction plans subsequently obtained, as discussed above, fact remains that the plaintiff that if the defendants appellants are permitted to make a construction over their chosen portion of the suit property, the same might create indefeasible rights which would inure to the benefit of the constructing party at the final hearing of the suit, thereby putting the plaintiffs to an unwarranted disadvantage. Full stop. Next para. Thus, on the premise of obtaining a sanction plan subsequent to a contested injunction order being passed, we cannot give such premium to the defendant's appellants. Full stop. Next para. That apart, the impugned order is otherwise sound in law and takes a view which is plausible in the eye of law and in the facts of the case, and it is well settled that an appellate court does not upset such findings merely because an alternative view might be possible in its opinion. Full stop. Hence, we do not find any reason or occasion to interfere with the impugned order. Accordingly, FMA 719 of 2023 is dismissed on contest, thereby affirming order number 33 dated June 7, 2023, passed by the learned civil judge, senior division, second court at Tomluk, district Purbo Medinipur, in title suit number 23 of 2021. Full stop. Can 1 of 2023 stands disposed of accordingly. There will be no orders to cost. It is expected that the learned trial judge shall make all endeavor to dispose of the suit as expeditiously as possible and without granting any unnecessary adjournment to either party. Full stop. The parties, including the plaintiffs stroke respondent numbers 1 and 2, shall extend their full cooperation with the learned trial judge to such end. It's very difficult for the courts, Mr. Shatra. It's very difficult for the courts because we are pressurizing them. We ourselves can't dispose of appeals and we expect the trial courts. Timeline, it's premature for that.
4 years already I am.
আচ্ছা ঠিক আছে একটা লাইন কমা দিয়ে একটা লাইন অ্যাড করে দাও যেখানে বললাম যে লাস্ট লাইনটা সেন্ড উইদাউট ইন অর্ডার টু কস্ট না ওই এক্সপিডিশিয়াস পসিবল যেখানে হ্যাঁ ওই লাইনটা কমা দিয়ে শেষে ফুলস্টপের বদলে preferably within 1 year from the date of communication of this order to the learned trial judge. ফিরে এসে যেগুলো কন্টিনিউ
36, my lord, I appear for the appellant, my lord. Husband is the plaintiff appellant before your lordship, my lord. My lord, suit is for the divorce, my lord, under section 25(1) and 25(3) of the Special Marriage Act, my lord. In that suit, my lord, an application challenging the maintainability of the suit was filed. My lord, that application has been allowed. My lord, no evidence has been taken yet, my lord. It has not reached the evidence stage. Holding that both section 25(1) and 25(3) are time barred, and hence the suit is dismissed.
Time barred?
25(1), so far as the non-consummation of marriage, my lord, it prescribes no time limit.
How can there be a time limit? There is non-consummation, it's a continuing cause of
My lord, but the learned
anyway. So, and three?
3, my lord, within 1 year, that is within time limit. In
So-
my humble submission, that the
I've got a copy of the act. আজকে বিকেলে আপনি একবার আমার পিএ কে জিজ্ঞেস করবেন তো কি কি বই আনাতে হবে, একটা জাস্ট রিমাইন্ডার দিয়ে দেবেন, আমাকে বলে দেবেন। তো আরেকটা বই দিচ্ছি দিন। So 3, there is a time bar.
3, there is time bar. So far as 1 is concerned, my lord, there is no time limit. My lord, my next submission will be, my lord, so far as the application was filed for maintainability, my lord. Concept of Order 7, Rule 11 ought to have been applied, my lord. That the averments made in the plaintiff, my lord,
No, a preliminary issue can be order 14 rule 2 can also be applied.
my lord, provided the
Maintainability is covered by 14.2.
my lord, but
No issue was framed here. Preliminary issue was
no, nothing, no issue was framed, my lord. Only at the hearing of the application, certain documents were filed, my lord, and the suit was dismissed. My lord had the occasion to hear the matter, my lord, on the 26th of November. My lord had passed an order, my lord, if we are available, my lord, page 1 of the supplementary paper book that we have filed. The order sheet, my lord, we have, in the impugned order, certain documents have been relied upon for previous litigation and pending litigations.
yes, yes. No, the learned trial judge also, why did the trial judge rely on Domestic Violence Act objection?
But that was filed, my lord, according to the learned trial judge. We have admitted that there has been consummation of marriage. That is the, my lord, that we have annexed, my lord. My lord will get the plaint filed by the appellant in the suit for restitution of conjugal rights from page 3. Page 3 to 14, my lord, is the plaint. In form, my lord, that has been filed, my lord.
But if you file a restitution of conjugal right, you admit the marriage.
My lord, that was specifically the page 4, my lord, the paragraph 2. That after solemnization of marriage, respondent not living with the husband as such.
Page 4, internal page 4.
Yes, my lord, running page.
Oh, acha. Form A. Form 1.
It is in form 1.
Yes.
Form 1 in the family court principal judge Dhanbad. My lord, paragraph 2. That after solemnization of marriage, respondent not living with the husband as husband and wife until now, and the respondent has come to know from a sosural that his sosural with her husband. The respondent is intentionally and knowingly started torturing and deserting on telephone in spite of the petitioner.
So not living was mentioned there.
It's
this restitution suit was dismissed.
At our instance, manner, it was withdrawn.
For default.
For default.
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 Yes, para 2 of the plaint also you state that there was no physical relation.
No,
Page 6.
Page 6, para 2 and para 3 that after the marriage, your petitioner tried to
That
hide
is
his
also
devil
there,
face.
yes.
So as such, my lord, there was no
No
admission.
physical relationship was clearly mentioned there.
Yeah,
So it was a misnomer, basically a
My lord.
wrong notion.
So far as the other, my lord, the written objection filed by the husband, my lord, in the domestic violence case, that my lord will find at page 60.
There also you admitted something. What was the premise of the trial judge?
Well,
Why was it referred to? In what context?
Well, the trial judge has come to a finding that marriage was somewhat. That is at page 51 of the paper book, my lord, the first paper book, my lord. Upon hearing both the sides at length and perusal of documents along with the documents filed by the both sides, this court finds that the husband admitted in his WO supported by an affidavit in the proceedings brought by the wife under DV Act that he has been residing in the house of the wife for a considerable period of time. He also declared in his document wife's address at Howrah.
But page 67 of the supplementary paper book, you say that you never lived. There was no relationship with the petitioner.
My lord.
Page 67 of your domestic
That
violence
has been
objection.
the consistent case, my lord.
Page 67
Page 67, internal page 8 of that.
Yes, it's specifically stated. Although under same roof, there is no
Thing, my lord, if it is remanded, my lord, I have to prove my case.
Yes, definitely. Definitely.
So far as the admission part, my lord, unless there is specific admission.
But regarding fraud and coercion,
that part,
your time
but plaint cannot be rejected
partially.
partially.
No, that finding will remain then. Let us see the proviso to section 25. Oh, you don't have a book, you have handed over to us. We'll just check up. As the second proviso to section 25 says, court shall not grant a decree if yes, A is clear. Within 1 year or live together even after discovering the fraud. So here it is beyond 1 year.
It is beyond 1 year.
According to your plaint, what is the, you have admitted that it was, when did you come to know of the fraud? What is the fraud?
Fraud as such, my lord, not specifically. So in so many words, my lord, it has not been stated.
So fraud, you are not pressing that.
My lord, exactly.
So we restrict ourselves to this other aspect of the matter.
Finality of non-consummation.
Non-consummation. So let us see the judgment once before going on to Mr.
But that is the paper book, my lord, page.
Yes, paper book.
Page 50 onwards. First paper book, not the supplementary.
So let us hear Mr. Mukherjee.
My lord, only thing, my lord, the fraud aspect, my lord, page 6 of the first paper book, my lord, paragraph 19 and 20, my lord, the plaintiff's contention is that he was not told that he will be kept as Ghar Jamai. That is the
as
Ghar Jamai. Page 6, paragraph 19 and 21.
that is not a material fraud. Let us say, Mr. Mukherjee, yes. Fraud, they are not harping on. Consummation, what is your answer to these two things? Both the written objection and the restitution suit, they filed a suit wrongly for restitution, but in that also they mentioned clearly that there was no consummation. So at this stage, whether the suit can be dismissed, as Mr. Sen rightly said, they have to prove the contentions on merits, on evidence. So why don't we allow the appeal right now and remand it to be heard on merits?
Now, my lord, in this context, my lord, they filed the suit for restitution of conjugal rights in Dhanbad, my lord. Now, that was filed on 4th of May 2019. Marriage was solemnized, my lord, on 16th of April 2018. Now, my lord, if your lordship kindly takes up the supplementary paper book. Supplementary paper book. If your lordship kindly comes to page 13. This is the application and the form that they have filled up.
This is the same as page 4.
Yes, same as
page 4. No, no. This is a more complete copy. Page 13 is a more complete copy.
Yes, sir.
Because the number of the suit is not there at page 4. Anyway, the same thing.
Same thing.
Yes.
Both are same.
Both are same, yes. Yes, Mr. Mukherjee, what do you say to
now, if your lordship kindly takes up, this is a petition after the cause title note. This is a petition under section 9 of the Hindu Marriage Act for restitution of conjugal rights. Immediately after that, the above named petition I most respectfully submit as under. The petitioner and the respondents are legally married, husband and wife. Their marriage was solemnized on 16/4/2008 according to Hindu customs, and after their marriage, both the petitioner
had been
and
living,
husband
live
been
together as
living-
husband and wife.
Yes, ma'am.
Live together as husband and wife.
Live together husband and wife,
Allah.
as husband and wife, and thereafter all blind.
Oh, yes, right.
After, and that next paragraph 2, that after the solemnization of the marriage, the respondent not living with the husband as husband and wife up till now, and the respondent has not gone to her sasural with her husband. The respondent is intentionally and knowingly started torturing and deserting on telephone mode, I think it is. In spite of petitioner still is willing to keep and maintain her in proper way. So one thing is not, first of all, the marriage was solemnized according to Hindu rights and customs. Subsequently, it was registered under
Consummation is not one of the Hindu rights and customs.
No. And subsequently, it was registered under the provisions of the.
No doubt about that. They are admitting that.
No,
They say
this they have never admitted that according to Hindu rights and customs. They say in their application, rather they are saying that there is no formal marriage has taken place.
Acha.
We are saying, Lord, that we have gone for a honeymoon at Darjeeling. We live together as husband and wife at Howrah.
These have to be decided on merits, Mr. Mukherjee. Because if your pleadings have to be looked into, then it has to be decided on evidence.
Without going into that, Lord, if your Lordship kindly looks at this petition only, this was a restitution of conjugal rights.
Right.
Lord, your Lordship knows better than me. This is a restitution of conjugal rights. If there hadn't been any conjugation of the marriage,
there is no question
of restitution does not arise at all.
All right.
And there are numerous judgments, Lord, starting from 1968, Punjab and Haryana, Lord. I couldn't find the others in the Harim, Lord. But unless there is a consummation of the marriage, the question of restitution doesn't arise at all. And independency of that application, Lord, they filed this application for annulment of the marriage under the provision of 25(1) coupled with 25(3). After 4 years of filing the application of this application under Section 9. 4 years.
When the present suit was filed, the restitution suit had not yet been dismissed.
No, it was pending.
Pending.
In the pendency of that suit.
Do you have a copy of the? Do you have a copy of the dismissal order, by any chance?
Not I can.
Yes, order of dismissal is there, page 40.
Yes.
Page 40. This is for default simplicity.
Dismiss for default. Not.
Yes.
9/8/2024.
So there is no adjudication in that suit. At best,
it was
an admission
withdrawn. It was not adjudicated, but it was pending.
No, Mr. Mukherjee, the effect can be yes, you are right that it can be at best constitute to be their admission that there was a marriage, Hindu marriage, but it cannot be neither operate as res judicata nor order 9 rule 9 because
I'm not
because now they are not filing a restitution suit. If they filed another restitution suit, that might have been, you might have argued that is barred by order 9 rule 9 because dismissal, it was never restored.
It was never restored, but this suit, filing of this suit itself is an admission, Lord, that they are asking for restitution of the conjugal rights.
If there is no conjugal rights,
if there was no conjugal rights, the question of filing a suit for restitution of conjugal rights doesn't arise. They could have at best filed a suit for divorce, not annulment of marriage, Lord. They had filed this annulment of marriage with an intentional purpose to avoid their responsibility that there was no marriage at all. It was a void marriage. And it will lead to an inevitable conclusion, Lord, that he doesn't have any responsibility at all. On the other hand, he had taken advantage of everything.
Mukherjee, the problem is whether the court could have decided it at the stage of your maintainability application without evidence being laid. Maybe he'll not be able to prove his case.
Lord, without going into any other aspects, on the face of this record only, Lord, without going into any other aspects.
You're on the connotation of the word restitution mostly.
Yes, Lord.
Because in that suit also they said that there was no conjugal relation, no consummation, no physical relation.
Kindly see how cryptic the averments are.
Very cryptic. But that has been dismissed for default.
And it was dismissed for default. And kindly see that the averments made in the application. Can it be relied upon by any court of law, Lord?
Which application?
The application under Section 9 that they have filed before the...
We are not concerned with that. That has been dismissed for default. We are not deciding on that suit.
Simply they are saying there is no consummation. They had never lived together. There was no physical relationship, nothing else. On the other hand, it is a fact that they had lived together. They had rented a house. They are staying together in Howrah. Those documents, at least they have also taken into consideration. They
That
did not
will be-
object to that, my lord.
No, there's no question, scope of objecting to that. Those were not proved in evidence. Where is this question of they're rebutting those?
Not at least the document, the objection that was filed, the application that was filed before
That is
the.
not a part of the pleadings in the suit. Pleadings is only plain and statement. Your objection cannot be a basis
In
for
the
deciding.
statement we have also stated, my lord.
Yes, that has to be decided on evidence. No, Mr. Mukherjee, if I don't find strength in your, you have made a very strong argument in as much as that restitution should be filed. But we'll consider the connotation of restitution in the conspectus of section 22.
Lord, in this respect, I'll be submitting this judgment, my lord, if your lordship kindly consider.
Yes, please. Have you got a copy of the Hindu Marriage Act by any chance? No.
Yes, my lord. Section 9, my lord.
Yes, section 9, exactly. Whether it's equivalent to 22. Probably language is same. You can read out for us also, Mr. Mukherjee, once.
When either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved party may
It's a copy
apply
paste. Special Marriage Act is a copy paste. Yes. Need not
by
read further.
petition to the district court for restitution of conjugal rights, and the court.
Mr. Mukherjee need not read further. We have read what we have got what we want. Yes. It's same up to this as the Special Marriage Act. We are concerned with up to this only of that section. Yes, for the judgment here.
1968, Punjab and Haryana, page 489. Lord, kindly considers paragraphs 17 and 18. Agree.
Mr. Mukherjee, you have to pronounce all the Latin expressions used. Then we'll allow you. In paragraph 7. But how is this directly relevant? It uses the expression renewal of cohabitation in certain places.
Exactly, not that. That is the
that
point.
that portion you are relevant.
Yes, no. The
Ecclesiastical court, yes.
Law, restitution of conjugal right was understood as a compulsory renewal of cohabitation between the husband and wife who have been living separately. That is the renewal.
But it also says the court cannot enforce sexual intercourse, but only cohabitation. So a distinction has been then drawn between sexual intercourse and cohabitation. In the same judgment, it uses the expression renewal and resuming cohabitation. But in the same breath, the middle sentence says the court cannot enforce sexual intercourse, but only cohabitation, thereby drawing a distinction between the two. And consummation is sexual intercourse. So your judgment itself is, in that sense, contradictory with your context. A distinction is drawn between consummation and cohabitation. Although in the normal sense, Mr. Mukherjee, you are absolutely right. Cohabitation, we mean consummation also.
Consummation.
But here itself, this judgment, it draws a distinction between sexual intercourse.
But the section itself says it is a consummation.
No, does not. Does not. Does not. That is what precisely we wanted. Withdrawn from the society, and cohabitation means living together. Habitation is living. Co means together. It may include within it its broader purview consummation also. But because Mr. Mukherjee, there may be a marriage where the parties don't want, need not consummate. There are several marriages in advanced years nowadays, at least. We have to see in modern perspective also. Marriage between a person who is 76, suppose, and the spouse is 69, suppose. So they don't have any consummation, but they marry all the same, and they have a cohabitation. Marriage has different shades of connotations. Yes,
it does happen.
So many instances. Among celebrities, we know. Among normal people, we don't know.
Yes.
So there are instances. So therefore, we were thinking whether a line of distinction can be drawn between, because specifically consummation is the term used in section 25, not cohabitation. Section 25 is consummation. Otherwise, it cannot be a nullity.
Yes.
That is where we are, joining issue with what you are saying.
And another point is not whether this is also required to be considered or not. Although there is a, as far as limitation is concerned,
yes.
Section 2 and 3, there is,
No doubt.
Section 2 and 3, there is a limitation of 1 year, that is clear enough. But Section 1, subsection 1, there is no limitation.
It has to be a continuing cause of action.
It has to be a continuing cause of action.
There cannot be any limitation.
But will that be a indefinite for an indefinite period?
Why not indefinite? The other spouse does not consummate for 12 years. On the 13th year, I may say, today I want that. But yes, you are right. It should be reasonable. But when was the marriage?
That is a point that has been also taken into consideration.
But that, it cannot be said at the threshold, Mr. Mukherjee, it's barred by law. That is where we are drawing a distinction. You may have a point, Mr. Mukherjee, in saying that the court may say that this is not a bona fide approach, or read something into their intention, or it's a malafide suit, or something like that. We could have understood that. But at the threshold, they cannot be shut out by saying that it's time barred. Because
as far as subsection 1 is concerned, the learned court below has not said that it is time barred.
No, there is a stray finding.
Subsection 3, he has said so.
Yes.
But as far as subsection 1 is concerned, he has not said so.
Where is
he
that?
Has said that there is there is no page 15. Page 15. First page.
50 of the other one.
From moreover.
Yes. Yes, you are right. Right.
As far as one is concerned,
It was argued. It was.
It was argued.
Yes, yes. Because moreover at page 50,
Yes.
about fifth paragraph from the bottom.
From
But that was an argument. You are right. Judge's order does not say that.
No, the
Yes.
order doesn't say so. So as far as limitation is concerned, he was restricted to only subsection 3. But non-consummation, only subsection 1.
Let us decide the appeal, Mr. Mukherjee. Any other judgment you want?
Yes, Lord. And that time limit concern.
Yes.
Concern, Lord.
Time limit regarding 3.
1.
Ah.
And another point which I would like to refer before your lordship, before that, Lord, also.
Yes.
There is a clear averment, Lord, in the application under section 9 that it was solemnized as per Hindu Marriage Act.
Yes, yes.
And it was registered under the provisions of Special Marriage Act. Now, if your lordship kindly looks at this judgment, Lord, 1975, AIR 1975, Calcutta, reported at page 6, Lord, Justice Layak and Justice N.C. Mukherjee. At page 6, paragraph 13, first, Lord, and Justice Layak, division bench, concurred in paragraph 7. May I place it, Lord?
Please.
Paragraph 7, 13 first.
Paragraph 13.
13. It was a judgment of justice delivered by Justice N.C. Mukherjee.
All right.
Mr. Satyendra Prasad Sen fully agrees with the submission made by Mr. Ghosh and goes a step forward when he submits that as soon as the marriage is registered under the provisions of Special Marriage Act and that marriage is deemed to be a marriage under the said act.
Paragraph 13.
13, my lord. At page 7. Judgment of Justice N.C. Mukherjee, Lord.
Oh, 2 judgments have been handed over together. Very well. Yes, 13, God. Satyendra Prasad. Please carry on from where you stopped. We will catch up.
Provisions of Special Marriage Act and that marriage is deemed to be a marriage under the said act. The previous marriage loses its existence and it becomes a marriage under the Special Marriage Act. And all provisions of the act would apply in such a marriage. We are unable to agree with the submissions made by Mr. Ghosh and Mr. Sen because there is a clear distinction between a marriage solemnized under the Special Marriage Act and marriage deemed to be solemnized under the said act. Section 25 lays down the grounds on which any marriage solemnized under this act may be annulled by a decree of nullity. This section does not lay down that a party to a marriage celebrated in other form and registered under this act can have the marriage annulled by a degree of nullity. Similarly, the section 24, which deals with the void marriage, lays down that any marriage solemnized under this act shall be null and void and may be declared by a decree of nullity on certain conditions enumerated in the section. As has been indicated in section 18, provides that a marriage celebrated in other form and registered under the Special Marriage Act will be deemed to be a marriage solemnized under the said act, and all children born from the date of ceremony of the marriage, whose names shall also be entered in the marriage certificate in book, shall in all respect be deemed to be and always to have been the legitimate children of their parents. It is thus seen that it is only for the purpose of sanctioning legitimacy to certain class of children that a marriage celebrated in other form and registered under the Special Marriage Act shall be deemed to be a marriage solemnized under the said act, and for no other purpose. Section 24 again makes a clear distinction between a marriage solemnized under this act and a marriage deemed to be a solemnized under this act within the meaning of section 18. Section 24 subclause 1 lays down that then the whole...
Mr. Mukherjee, they don't say that in any of the pleadings that it was solemnized as per Hindu rights and customs.
See the application?
See it. Come
Once
to page
again,
6.
Lord.
Come to page 6 of the supplementary.
Kindly see again page 3, Lord, of the special.
No, but in the pleadings it's not there.
Yes, Lord, in the pleadings. paragraph 1, the petition and the respondent are legally married husband and wife, and their marriage was solemnized on 16/4/2018 according to Hindu customs and Hindu customs. After the Hindu customs, specifically stated.
But in the pleadings, it's not there. Page 5.
This is the pleading, Lord.
Plaint is the pleading. The plaint is in at page 5.
This is a mandatory form that they have filled up.
It's in contradiction with the pleading. Main pleading, kindly see page 6. The marriage was solemnized on such and such in front of Ratna Singhu, marriage officer. So it's a special marriage act marriage. So if that is contradictory,
that is registered.
Exactly.
But here there
is. It was solemnized on 16/4 in front of marriage officer.
And before that, on the same date, it was solemnized according to Hindu customs. That is the averment on oath before the court, family court. On oath.
Averment on oath is the plaint.
And
not this form.
This is the form.
The verification.
He has verified that.
Verification is to the plaint, to the petition under section 9.
And this is also a mandatory form, Lord.
Can the mandatory form prevail over plaint? Yes, there is a verification there also. You're right. In at page 4 also there is a verification. So from this we do not get, suppose if we proceed on that premise also, we do not get which was first, Hindu marriage or special marriage?
On the same date.
If on the same date, then if the special marriage was contracted earlier, then that prevails. Because the judgment which you cited correctly says that if there was a Hindu marriage subsequent...
On 16/4/18, it was, first of all, it has to be usual practices, Lord, that marriage is being performed and thereafter it is being registered.
That is the law, but that is not the usual practice. Mr. Mukherjee, what happens every day, you will see people get married before a marriage register. Marriage register comes to their house, they get a signature and the marriage is registered. Subsequently, they perform a social ceremony. It is happening every day. This season itself, I have ate so many such invitations. Marriage was performed every time I point out, but I am ostracized by my family for that. That you cannot have a Hindu marriage registered before they do a special marriage registration first. They book themselves so that they are not engaged with someone else, and subsequently carry out the Hindu rites, whatever. Social marriage, they call it social marriage. So that happens every day. There is no usual practice on this. But law provides that a Hindu marriage can be registered only after the marriage. You're right. But they say that the marriage was Hindu rites and customs marriage took place on 16th.
Lord,
and in the same breath, they say special marriage took place on.
Your Lordship kindly now, coupled with this application and the application filed under section 9 of the Hindu Marriage Act.
Yes.
It goes to suffice, Lord, that intentionally the section 9 application was filed because there was a solemnization of the marriage under the provisions of section 9.
On the contrary, Mr. Mukherjee, even in the plaint filed in that, they did not say, they said the marriage was in front of a marriage officer, and this form only was filled up by, we don't know who. It's a typed form. He only signed it. This may be done by a clerk.
But it was verified by him, Lord. He's a doctor, Lord. He's a doctor. He's not an illiterate.
Even if he was an advocate or a judge, even then the same thing applies. How many people look into all the nitty-gritties of their marriage form?
Lord, that he has to take the responsibility, Lord.
Yes, but there is a contradictory pleading on his part only. In the very next, in the original plaint,
Lord,
that's a printed form.
Lord, on
and
the other
there's a
hand,
plaint.
If I may respectfully submit, Lord.
Mr. Mukherjee, even if you take your best case, in the same pleadings, he says that there was a Hindu marriage, there was a special marriage on the same day. He does not say which came first. So that has to be decided on evidence in the suit also. You can take a point. This is a very valid point. If there was a prior Hindu marriage and a subsequent special marriage, the moment the Hindu marriage took place, they became married. there is no scope of the subsequent special marriage was superfluous. So it has to be under the Special Marriage Act. This suit will be barred. This present 25 suit.
Annulment.
Yes, that point you can take. But if they can show that the special marriage was prior and the rites were performed later, if at all, then the special marriage, the moment the special marriage took place, it was a valid marriage. They are a married couple. Hindu marriage then would be superfluous. So it is not evident at this stage. We are not deciding an appeal against the final adjudication on merits. I mean, on evidence. If that was so, you would have a valid point there. We'll record your submission, but Mr. Mukherjee say that it's not possible to say at this stage which is which. I mean, which took place first.
Page 75.
No, let him complete then come. Yes.
So, my lord, this, as far as this is concerned, and another point, my lord, that I was submitting, my lord, regarding limitation.
Yes.
Lord, EIR 2000, Calcutta, at page 76, Lord. Paragraph 9. Sorry. Lord, often we see, Lord, that when an application under subsection 1 is filed, Lord, we say that there is no limitation and the cause of action is unlimited. Lord. It goes on.
Yes.
And it is a continuous cause of action. And at any time it can be filed. But it is not so, Lord. There has to be an end point to that limitation. Because that cannot go on forever, and that will become a tool in the hands of the erring party.
Let us see the judgment.
Kindly see paragraph 9, Lord.
Yes, please.
Supreme Court decision in AIR 1989, Supreme Court page 1477 can thus be unhesitedly cited as an authority for the proposition that the provisions of the Limitation Act will not apply to any suit or any other proceedings under any marriage law. In other words, the provisions of Limitation Act cannot apply to the instant suit or proceedings under the Special Marriage Act. It is submitted by Mr. Datta that if it is held that the provisions of Limitation Act do not apply to a suit under Section 25(1) of the Special Marriage Act, and since Section 25 does not prescribe any period of limitation for filing such a suit, it would follow as if there is no time limit at all for filing a suit under Section 25(1) of the Special Marriage Act. And in that case, it would lead to an absurd proposition. To repel this contention, Mr. Mukherjee refers to clause E of subsection 1 of Section 34 of the Special Marriage Act, which clearly puts an embargo upon the courts to grant relief in such a proceeding if there has been an unnecessary or improper delay in instituting the proceeding. And it is only when the proceeding reaches the stage for deciding the question whether the relief claim should be decreed or not, that the occasion will arise for the court to decide the question whether there has been any unnecessary or improper delay in instituting the proceedings under Section 25(1) of the Special Marriage Act. The impugned amendment will be evidently take effect from the date of the suit, and even if the contention of Mr. Datta is accepted, that the amended relief would be governed by the residuary article of the Limitation Act. The period of limitation is to be computed from the date on which the right to sue arose, and the right to sue for annulment of the marriage under Section 25(1) of the Special Marriage Act arise only after there is a willful refusal of the respondent to consummate the marriage, and certainly it would not be said to have arisen on the very date of the marriage. Thus, considering the question of delay from all angles, it must be held that delay in specifically claiming the relief under Section 25 of the Special Marriage Act cannot be considered to be unreasonable. This is in fact of the case. Now, as far as this is concerned, so it has to be computed from a particular date. Now, your lordship, if your lordship kindly looks at the application that they have filed under the provision
on the first day, their allegation is that you did not.
We did not consummate. So the limitation has to be there, Lord.
Can we read limitation? Can we read limitation into a statute where there is no limitation provided? Section 34 here also was held and argued that it can be decided only
If your
at the
lordship
time
kindly
of
looks at
final hearing.
Section 34 of the Act, not itself.
34 says unreasonable delay, but whether it's unreasonable or reasonable, that will be decided at the final hearing. Even here it is argued in your cited judgment, puts an embargo upon the power to grant relief in such a proceeding. And it is only when the proceeding reaches the stage for deciding the question whether the relief claimed should be decreed or not, that the occasion will arise for the court to decide the question whether there has been any unnecessary or improper delay. So the stage is only when the proceeding reaches the stage for deciding the questions. The issues are decided.
Marriage was solemnized on 16/4/2018.
That stage has not come to decide
After
whether it's
5 years.
unreasonable or reasonable. That has to be decided on merits.
But after 5 years, he's
5 years is not a cut-off date. There is no limitation in the statute. There is no year limitation in the statute.
Maybe, my lord.
Unreasonableness has to be decided at the final hearing.
But my humble submission in this regard, my lord. But 5 years limitation. If 5 years is computed to be a reasonable or unreasonableness is to be considered, my lord. 5 years under no stretch of imagination can be considered to be a reasonable delay.
We know of delays of 13 years, 24 years being condoned. Probably you may also have been a party to one.
Lord, in that case, your lordship must have taken into consideration the grounds for delay. Lord.
That stage of taking into consideration has not come, Mr. Mukherjee. At the threshold, they cannot be shut out by saying you have come after 5 years, so you're gone.
Himself has stated in that application, Lord, that it has not been consummated. He has filed an application under Section 9. And he goes on saying that the day after day, year after year, waiting for the same.
According to him, it may be reasonable. He was always all along willing to take her back. So there is no question of unreasonable delay because his cause of action finally arose when he got fed up and said no, let there be a degree of nullity.
By pleading fraud.
And non-consummation.
And on the other hand, he is filing an application for restitution of conjugal.
Any other judgment, Mr. Mukherjee? Yes, Mr. Sen, any reply?
Only thing, my lord, so far as the marriage is concerned, my lord will kindly consider page 75 of the supplementary paper book, my lord. There is a letter to the officer in charge by the wife, my lord.
But just another point, my lord. There is a mediation also, my lord, effort. In the mediation effort, he did not turn up.
Fourth paragraph, my lord. It was decided by both the family members that we will marry once his education is completed. Hence, we got married under Section 13 of the Special Marriage Act on 16th April 2018 before the marriage register, such and such.
Now, where do we get this document? This was produced by them?
My lord. 498A complaint, my lord.
It would be premature to consider this document also.
My lord, so far as limitation is a question of mixed question of law and fact, my lord. Unless, my lord, we are entitled get him in the box, we have to cross-examine him, my lord, documents have to come up, but thereafter it can only be decided.
Ashok. The husband, the plaintiff struck husband in a suit for declaration of the marriage between the parties to be a nullity under Section 25 within bracket small I and small III of the Special Marriage Act, 1954 is the appellant before us. Full stop. By the impugned judgment and decree, the learned trial judge allowed an application filed by the defendant wife challenging the maintainability of the suit. Full stop. The learned trial judge proceeded on the premise that insofar as the relief under Section 25 within bracket III is concerned, the same is palpably barred by limitation since the proceedings were instituted beyond 1 year after the alleged fraud was discovered. Full stop. Insofar as the relief under Section 25 within bracket small I is concerned, the learned trial judge, Mr. Mukherjee, yes, you can take your seat. The learned trial judge was of the opinion that it is evident from the written objection filed by the appellant husband in a proceeding under the Domestic Violence Act that the parties have been residing together after the marriage. Full stop. Moreover, comma, the learned trial judge also was of the opinion that in a previous suit filed by the husband for restitution of conjugal rights, comma, it was admitted that the husbands, the spouses were leading a conjugal life. Full stop. Next para, learned counsel appearing for the appellant fairly concedes that insofar as the ground of nullity under section 25 within bracket small III is concerned, comma, the same appears to be barred by limitation on the face of the plaint. Full stop. However, comma, insofar as section 25 within bracket small I, that is non-consummation of the marriage is concerned, comma, the learned trial judge the learned trial judge overlooked that the husband, comma, in his plaint under section 9 of the Hindu Marriage Act, comma, in a previous suit for restitution of conjugal rights, comma, categorically averred that the petitioner and the respondent have not been living together and there is no physical relationship between them. Full stop. Moreover, comma, it is contended that in the written objection filed by the appellant husband in the domestic violence proceeding as well, comma, it was categorically pleaded that although the spouses lived under the same roof, comma, there was no relationship between the parties as husband and wife. Full stop. It has also been alleged that when the present appellant tried to cohabit with the respondent, comma, she, comma, on some false and flimsy ground, comma, avoided the same. Full stop. Next para. Thus, comma, it is argued that the very premise of the impugned judgment is bad. Full stop. It is contended that at best, comma, the plaintiff stroke appellant stroke husband is required to prove his plaint case at the trial stage, but the appellant could not have been shut out at the threshold by the learned trial judge. Full stop. Next para. Learned counsel appearing for the respondent wife controverts the arguments of the appellant. Full stop. Learned counsel places reliance on the printed form under section 9 of the Hindu Marriage Act, which was filled in by the appellant husband while filing his previous suit for restitution of conjugal rights. Full stop. In paragraph number 1, in the pleading portion thereof, comma, it was categorically averred that the marriage between the parties was solemnized on 16/4/18 according to Hindu customs, and after the marriage both the petitioner and the respondent had been lived together as husband and wife. Full stop. Next para. That apart, comma, it is argued that the very fact that the appellant husband filed a suit for restitution of conjugal rights presupposes that they had a conjugal life previously, comma, since the expression within double inverted restitution, double inverted clause, connotes restoration, comma, which obviously means that something which was previously existent was sought to be restored. Full stop. Thus, comma, in view of such admission of the husband as to the parties having led a conjugal relationship, comma, the learned trial judge was justified in passing the impugned judgment. Full stop. Next para. Learned counsel appearing for the respondent cites the judgment of a learned single judge of the Punjab and Haryana High Court in such and such reported at AIR 1968 P&H 489 in support of the proposition that that an application for restitution of conjugal rights means that the petitioner seeks a renewal of cohabitation with the spouse who had started living separately. Full stop. As such, comma, it is argued that the filing of the restitution suit by the husband itself indicates that there was a conjugal relationship between the parties which was sought to be resumed. Full stop. Next para. Learned counsel for the respondent next cites a judgment of a learned single judge of this court in the matter of such and such, reported at EIR 1975 Cal 8, where it was laid down that where it was laid down that where the learned single judge refused to accept the contention that as soon as a marriage is registered under the provisions of the Special Marriage Act, comma, the same is deemed to be a marriage under the said act, and the previous marriage under a different law loses its existence. Full stop. It was considered by the court in the said case that Section 25 of the Special Marriage Act lays down the grounds on which any marriage solemnized under the said act may be annulled, and does not contemplate the annulment of a marriage entered into under some other statute, including the Hindu Marriage Act. Full stop. Next para. Borrowing from the said concept, comma, the respondent argues that since the husband had admitted in his printed form under Section 9 of the Hindu Marriage Act that marriage was contracted by under Hindu rites and customs, comma, a subsequent marriage under the Special Marriage Act could not change the statute under which the marriage was solemnized. Full stop. Next para. Thirdly, comma, learned counsel appearing for the respondent cites another judgment of a learned single judge of this court in the matter of such and such, reported at AIR 2000 Cal 76. Full stop. In the said judgment, comma, the learned single judge had observed that Section 34 of the Special Marriage Act provides an embargo on the court to grant a relief in a proceeding under the said act if there is an unnecessary or improper delay, and it was observed that the starting point of the limitation for filing a suit under Section 25 within bracket small 1 of the Special Marriage Act would arise only after there was a willful refusal by the respondent to consummate the marriage. Full stop. Next para. Thus, comma, it is submitted that although the statute does not provide a specific limitation period for initiating a proceeding under Section 25 within bracket small I of the Special Marriage Act, comma, the courts, comma, in the light of Section 34 of the said act, comma, have held that unless the proceeding is initiated within a reasonable period, comma, the same should be dismissed. Full stop. It is submitted that in the present case, the present suit was instituted after 5 years from the marriage, and as such, comma, the same was rightly dismissed at the outset. Full stop. Next para. The first question which arises upon hearing learned counsel is whether the marriage, whether the suit filed by the plaintiff stroke appellant stroke husband under Section 25 within bracket small I is barred by limitation. Full stop. Next para. A bare reading of Section 25 clearly provides that although a statutory limitation period has been prescribed with regard to a relief sought under subsection small ii as well as subsection small iii of the said section, comma, no such fetter has been imposed with regard to a relief of nullity sought under clause small I of Section 25 on the ground of non-consummation of the marriage. Full stop. it is not for the court to read a limitation period into a statute where the legislature, comma, in its wisdom, comma, has specifically omitted to incorporate such a fetter. Full stop. In fact, comma, the very fact that limitation periods have been prescribed for a suit filed on the ground, a suit filed for annulment of marriage under the other two clauses of section 25, that is clause small ii and clause small iii, but such limitation is not imposed for a suit under clause small I, comma, itself is sufficient to show that the intention of the legislature was specifically not to include any limitation period for a suit for declaration of the marriage to be a nullity on the ground of non-consummation of marriage. Full stop. Next para. Learned counsel for the respondent has cited Supriyo Chakraborty Supra in support of his contention regarding limitation. Full stop. However, comma, in the said matter, comma, the court was considering the submission of one of the parties to the effect that Section 34 of the Special Marriage Act puts an embargo upon the court's power to grant a relief where there has been an unnecessary or improper delay in instituting the proceedings. Full stop. However, comma, even in the said case, comma, the learned single judge did not lay down a ratio that there is any limitation period whatsoever for a suit under section 25 within bracket small I of the Special Marriage Act. Full stop. In fact, comma, the party which advanced the argument on section 34 itself had also submitted that it is only when the proceeding reaches the stage for deciding the question whether the relief claimed should be decreed or not that the occasion will arise for the court to decide the question whether there has been any unnecessary or improper delay in instituting the proceeding under section 25 within bracket small 1 of the said act. Full stop. Next para. Hence, comma, it is only at the stage of final hearing of the suit that the court may or may not consider the question as to whether the relief claimed in the present suit ought to be turned down on the ground that the same was filed with an unnecessary or improper delay. Full stop. The said issue, comma, if at all raised after having been formulated by the court, comma, has to be decided upon evidence being adduced by both the parties and on a full-fledged trial, and could not have been a ground for dismissing the suit at the threshold stage. Full stop. Thus, comma, we are unable to accept the submission on such count made by the respondent. Full stop. Next para. Next comes the question as to whether the suit filed by the present appellant for nullity ought to have been dismissed at the outset on the ground that the husband has admitted that there was consummation of marriage between the parties. Full stop. Next para. We, comma, however, comma, are unable to convince ourselves in that regard. Full stop. It may be noted here that the pleadings, comma, as per the definition given in the Code of Civil Procedure, comma, comprise of the plaint and written statement of parties. Full stop. The purpose of a printed format, comma, which is used in certain jurisdictions, comma, is to bring before the court the necessary facts of the case in a nutshell. Full stop. However, comma, it is only the plaint which comprises of the pleadings of the plaintiff, and it is open to the plaintiff, comma, in the plaint, comma, to incorporate further details even beyond the printed form. Full stop. Next para. Although the printed form in the present case was supplemented by a verification signed by the husband, comma. In the very same case, comma, the husband also filed a proper plaint within the contemplation of Orders 6 and 7 of the Code of Civil Procedure, which was also verified. Full stop. In paragraph number 1 of the plaint, comma, it is merely stated that the petitioner and the respondent are legally married husband and wife, and their marriage was solemnized on 16/04/18 in front of Ratna Singha, comma, marriage officer. Full stop. Thus, comma, from the very statement, it is evident that the marriage was solemnized not as per Hindu rites and customs, but before a marriage officer, comma, indicating that it was a marriage contracted under the Special Marriage Act. Full stop. The statements regarding the marriage being according to Hindu customs as found in the printed form are the usual printed averments which are there in the form even before the filing of the same. Full stop. It is customary that in jurisdictions requiring such forms to be filed, comma, the relevant blanks are filled up by the parties, and the same provides, in a nutshell, the rudiments of the facts of the case. Full stop. In the present case, comma, we thus cannot rely on the averments of the printed form and hold that those override the averments of the husband in the main plaint of the restitution of conjugal rights suit. Full stop. Para. Even if he proceed on the premise that the husband took a contradictory stand in his previous suit regarding the act under which the marriage was solemnized, comma, it is not clear from the said contradictory averments as to which marriage took place prior to the other. Full stop. Whereas in the printed form, comma, the date of the marriage is mentioned as April 16, 2018, comma, the same date is also mentioned in paragraph number 1 of the plaint. Full stop. In the absence of any clinching proof or averment to show that the Hindu marriage took place prior to the special marriage, comma, it is beyond the jurisdiction of the trial court and of this court to hold at the outset that the suit under the Special Marriage Act was bad in law. Full stop. In any event, comma, the said issue was a non-issue in the impugned judgment, and having not been raised before the learned trial judge, comma, we cannot dwell at length over the same. Full stop. As such, comma, the judgment of the Punjab and Haryana High Court cited by learned counsel for the respondent is not directly relevant in the context. Full stop. Next para. It is also important to note that in the said judgment of the Punjab and Haryana High Court in the case of Captain B.R. Syal, SYAL, Supra, comma, the Punjab and Haryana High Court had distinguished between sexual intercourse and cohabitation and had observed that in a suit for restitution, comma, the petitioner seeks renewal of cohabitation. Full stop. Next para. The expression double inverted cohabitation, double inverted clause, comma, in plain English, comma, means joint living, joint residence and or living together. Full stop. The same may or may not include sexual intercourse, comma, which is the exact synonym of consummation within the contemplation of the Special Marriage Act. Full stop. Thus, comma, it may very well be that the parties cohabit with each other, but there is no consummation of the marriage between the parties by way of sexual intercourse. Full stop. Next para. Section 22 of the Special Marriage Act as well as Section 9 of the Hindu Marriage Act provide for restitution of conjugal rights. Full stop. The language used in both the said provisions is that when either the husband or the wife has, without reasonable excuse, withdrawn, tapra italic say. from the society of the other, এটুকুনি italic say, comma দিয়ে dot dot dot, full stop. The society of each other, comma, might or might not include consummation of marriage between the two by way of sexual intercourse, and as such, comma, even if the expression restitution is taken on face value, comma, a suit for restitution of conjugal rights can only mean that the plaintiff seeks a restoration of the cohabitation, that is living together of the parties as husband and wife, comma, although the underlying intent may or may not be of consummation. Full stop. Next para. We must also not be oblivious to the present social context in that regard. Full stop. In the modern day, comma, there are several marriages of people between people of advanced years or otherwise, comma, where consummation is an unnecessary appendage to the marriage. Full stop. Marriage has several connotations much beyond the limited perspective of consummation, and the parties may very well want to live a matrimonial life without having sexual intercourse between the two. Full stop. Thus, comma, we cannot restrict the meaning of marriage to uh, to archaic expressions which were previously used to connote the entire perspective of marriage within the restriction of sexual intercourse. Full stop. Next para. Seen from such perspective as well, comma, a suit for restitution of conjugal rights may or may not imply that there was prior sexual relationship between the parties, comma, which is precisely the synonym of consummation. Full stop. Thus, comma, looking at the matter from the said angle as well, comma, we do not find that mere institution of a prior suit for restitution of conjugal rights necessarily means an admission, comma, that too an unqualified admission, comma, on the part of the husband that there was consummation between the parties. Full stop. In any event, comma, we need not dwell at such length, comma, since in paragraph number 2 of the petition under section 9 of the Hindu Marriage Act, comma, the appellant husband had categorically mentioned that after marriage the petitioner and respondent are not living together and do not have any physical relationship in between them. Full stop. Insofar as the written objection filed by the husband in the domestic violence proceeding initiated by the wife, comma, in paragraph number 10 of the said written objection, comma, the appellant husband, comma, in no uncertain terms, comma, stated that though the parties lived under the same roof, comma, there is no relationship between the two as husband and wife. And when the husband tried to cohabit with the wife, comma, she avoided the same. Full stop. Thus, comma, we do not find at any point of time that the husband admitted consummation having been undertaken between the parties. Full stop. The expression cohabitation cannot by any stretch of imagination be equated only with consummation as discussed above. Full stop. Next para. Thus, comma, the learned trial judge erred in law and in fact and proceeded on a complete misappreciation of the previous pleadings of the appellant husband to dismiss the suit at the threshold on the ground that the husband had admitted previous consummation between the parties and disbelieving the ground taken by the husband under section 25 within bracket small I of the Special Marriage Act. Full stop. Next para. In such view of the matter, comma, we are of the opinion that although the learned trial judge was justified in holding that the ground under section 25 within bracket triple I taken by the husband in his suit for declaration of the marriage as a nullity was time barred, comma, the learned trial judge completely erred in law on the other aspect of the matter in dismissing the suit even on the ground of section 25 within bracket small I of the Special Marriage Act. Full stop. Next para. Accordingly, FA 111 of 2024 is partially allowed, comma, thereby setting aside the impugned judgment and degree so far as the dismissal of the suit is concerned. Full stop. The matter is thus remanded to the trial judge, to the learned trial judge, for hearing the same on merits upon granting opportunity to both parties to adduce evidence in accordance with law and holding a full-fledged trial, comma, but restricted only to the ground of non-consummation under section 25 within bracket small I of the Special Marriage Act 1954, full stop. The finding of the learned trial judge insofar as the suit is barred, insofar as the relief under section 25 within bracket triple I of the said act is barred, is hereby sustained. Full stop. Next para. In view of the implicit urgency involved in the matter, comma, it is expected that the parties will cooperate with the learned trial judge to ensure that the suit is decided on merits at the earliest. No address to cost. Thank you. Thanks. Oh.
In this matter, I am appearing for the appellant because I have some difficulty. Lord, because this is
the last chance given to you, Mr. Ghosh.
That I know.
Yes.
Because this relates to some of my family members. That's why
Oh.
Tanmay Mukherjee is assisting me in this matter. So he is on his legs in court number 15. And another difficulty is from tomorrow I will be out of station for 7 days. So
You need not be here. Mr. Mukherjee will be here. You should be impersonal in this matter.
Oh,
Mr. Mukherjee will be there.
yes, if you will kindly fix it after 17, that will be better.
No, we'll keep it on Monday, Mr. Ghosh. Keep it on Monday.
Monday.
Although a last chance was given to the appellants to argue the matter, comma, taking into consideration the unforeseen circumstances as submitted by learned counsel for the appellants, comma, the same is adjourned till January 13, 2025. No, Mr. Ghosh, you don't be there when the matter is heard. Your relatives matter.
Sometimes assistance is required because
No further time, Mr. Ghosh. Sufficient time has been. This was the last chance.
Yes.
Since you said that it pertains to your relatives, we have only for that reason we have adjourned for a day. Otherwise, we would not have. Monday. Yes. Mr. Subhashis Ghosh. Yes. This is an order for 10 matter.
Yes, sir. My lord, I'll start the matter. My lord, Mr. Chaudhary will.
No, I don't think we don't think that will be a prudent thing to do because today you have a 3:30, so 8 minutes left.
So we'll take it up on Monday.
Take it up on Monday.
Monday.
In view of paucity of time, let the matter stand adjourned till January 13, 2025. পাস করার মধ্যে দুটো আছে ফর্মালি ডেকে দিন হবে না আজকে
Yes. My apologies, I could not be there when the matter was.
This is item and board.
This is item number 29, ma'am. Lordship, this is perhaps only the memo of appeal is there, Lordship. The application has been filed today. That is what I've been told. Today. Lordship, if I may kindly indicate, Lordship.
Give a number of that application. It will appear.
Lordship, it would be CAN 1 because that is.
No, on a slip of paper, formally give it. So that it can be called a requisition.
Absolutely.
So this will appear on Monday along with the. No, it cannot. If you have filed today. We'll keep it on Tuesday.
Tuesday.
Difficulty.
If it can be on Monday, it won't come.
You have filed today. Will it? When did you file?
Today.
Today when? Before recess or after recess?
I think post recess. That is what.
Will it come on Monday? We don't know. You'll know better.
I'll try to get it listed on Monday.
No, we on presumption we cannot. You have to check up whether the number, what is the number, actual number, whether a number has been allotted, whether it could be filed actually. Learned counsel for the appellant submits that an application in connection with the appeal has been filed today. Full stop. Learned counsel is requested to furnish the number of the said application during the course of the day. Full stop. Let the matter appear under the same heading on January 13, 2025, along with the said application. Give the number, ascertain the number, give the number. We shall send a requisition and no requisition is required because it will come. এই অ্যাপ্লিকেশনটা সঙ্গে দিয়ে দেবেন, এই হেডিং এ থাকে। None appears on the second call. Full stop, let the matter stand adjourned for the day.